Internet for item one.
Right. Also, we had already taken the consent from the other side. SSA was directed to file an affidavit here. We are still in the process of preparing our affidavit. Also, kindly fix any date after we file our affidavit in the meanwhile.
Is the request made by the council? Sixth of May.
Right. Apology. I was about to mention an item number 37.
It is over. Item 37.
37, Your Lordship. Your Lordship, the land council has personal difficulties, so he will not be able to do the matter today. Your Lordship.
37 for respondent.
Petitioner for petitioner, Your Lordship. We have taken the consent from the other side.
37.
Your Lordship.
37 again. After what? Yes. Item 2.
May please, Your Lord. My lord, the fact of the matter is that, my lord, the petitioner, my lord, at the relevant point of time was working in the wagon repairing shop, which was
Yes.
my lord, the establishment of wagon repairing shop was. My lord, I'm from the railway, my lord. My lord, I'm for the railway, my lord. I'm challenging the order of my lord, learned labor court, my lord. So, my lord, which is the judgment was in their favor, my lord. Against that judgment, my lord, we have prepared this petition, my lord. The wagon repairing shop was closed, and this staff of that wagon repairing shop deployed in carriage wagon department of NF Railway. The respondent, along with other surplus staff, were kept separately by creating supernumerary posts. And establishment of those staff were maintained in the office of mechanical section of the chief personnel officer NF Railway Maligaon. The respondent was promoted to the post of grade 1 of Turner category under the chief mechanical engineer NF Railway Maligaon. According to the respondent, he should have been merged with the seniority list of carriage department, but they were kept separately and they were deprived of their rightful expectation for getting promotion in time. Now, my lord, I have produced some documents, my lord, regarding, my lord, the railway board circular, my lord, master circular, my lord, possibly find, my lord, there, where, my lord, regarding, my lord, redeployment of staff of the department which were closed down, my lord. The master circular says, my lord, master circular number 22, my lord. At, my lord, 17, my lord, at page, my lord, third page, fourth page, my lord. Lord, you will find 17, my lord. Serial number 17, my lord.
One. Yes.
Malad, uh, serial number 17, my lord, it is of the master circular number 22, case 5, my lord. This is para 17, my lord.
Pa- okay. Page number?
Case number 5, my lord. It is giving, my lord, some documents were given separately, my lord. Lots of people find, my lord, at the beginning of the that file, my lord. There is a master circular, my lord. Master circular number 22, my lord.
Yes.
Master circular, my lord, losses comes to case number 5, my lord. 5, my lord. Para 17, my lord. Probably it is highlighted also, my lord.
Yeah.
Para 17, my lord. When redeploying of surplus staff to other units, departments which constitute a different seniority unit, the following methods could be accepted. If only a small number of staff are being rendered surplus and they have been transferred to various units of other departments against vacancies of duly sanctioned posts, they can be suitably adjusted in this unit with their full seniority and merging their seniority in respective units. Now, my lord, there are different kind of trades, my lord, Peter, Turner, my lord. Now, what happened, my lord, in the garage department, my lord, there are various people working. My lord, some are working as Peter, some are Turner, my lord, some are machinists, my lord. So, only 2-3 people were, my lord, since it is closed down, my lord, they were transferred to mechanical department. But they were kept separately as per this circular, my lord. But their seniority were merged, my lord, as per this circular. And after merging this seniority, my lord, this respondent, my lord, he became third, my lord. So, my lord, in 2005, my lord, another person, his name is Mr. Sarkar. He was first, my lord, in 2005. He was promoted, my lord. And second, my lord, his name is H.G. Rabha, my lord. H.G. Rabha was promoted, my lord, and the specific allegation is that, my lord, that the H.G. Rabha was promoted and he was deprived of this promotion, my lord, in 2006, my lord.
Yes.
Now, my lord, but this seniority, my lord, position was drawn up, my lord, as per this circular, my lord, of the railway, my lord. There is no, my lord, procedural error, my lord. And, my lord, since he was a junior to, my lord, H.G. Rabha, my lord, H.G. Rabha was promoted, my lord. H.G. Rabha was promoted, my lord. And, my lord, against that, my lord, he has come. And, my lord, if your lordship now comes to page number 12, my lord, of the judgment of the tribunal, my lord.
What was
Labor court, my lord.
what
Page
was
number
the
12.
finding of the labor court?
My lord, I will go to that, my lord. My lord, page number 11, my lord, it is the judgment, my lord.
Yes.
My lord, I like to read, my lord, para 30, my lord, which is at page 12, my lord.
Para 30.
My lord, page 12, my lord. Page 12, my lord, the award, my lord.
Yes.
Page 12, my lord.
Yes.
My lord, para 3, be it mentioned, my lord, para 3, be it mentioned here that remaining 5 other workmen, namely N.G. Mitra, Sri Khagendra Singh, Kaliram Borua, H.G. Rapa, and Swapon Das appeared to their general secretary and learned advocate and submitted written statements stating inter alia that Sri N.G. Mitra, Khagendra Singh, Kaliram Borua were working as turner and Sri H.G. Rava and Swapon Das were working as machinists under the wagon repairing said local running shop at Pandu. And after rising the industrial dispute, Subhash Chandra Bronik retired from service on superannuation without getting his due promotion and seniority. However, the remaining 5 workmen as aforesaid got their promotion with seniority. Hence, the aforesaid 5 number of workmen have no further grievances before the tribunal. does only workman Sri Subhash Chandra Bonik remains in the frame. So, my lord, these 5 persons, my lord, altogether they have raised the dispute, my lord. But during the, my lord, after raising the dispute, my lord, S.G. Rabha, my lord, who was one of the, my lord, my lord, complainant, my lord, who raised the dispute, my lord, they got the promotion, my lord. So, my lord, the grievance of the petitioner that H.G. Rabha was promoted, my lord, he was one of, my lord, of the applicant, my lord, before the learned, my lord, labor court, my lord. But since he was senior, my lord, and my lord, as I have shown, my lord, from the, my lord, master circular, my lord, how the seniority is to be maintained, my lord. H.G. Rabha was given because there is one post vacant, my lord, for master craftsman, my lord. So H.G. Rabha was promoted, and my lord, this Subhash Chandra Bonik could not be accommodated, and he retired, my lord, from service, my lord. So he was left in the frame. Other left, my lord. So he proceeded with the dispute, my lord. And the judgment, my lord, at the last page, my lord, I'll bring your lordship to the relevant portion of the order, my lord. Page 23, my lord. Page 23.
Yeah.
Para 18, my lord. May I read, my lord?
Yes.
Para 18. In the instant case, the rule of seniority and fixation on number of posts of master craftsmen, as well as the promotion prescribed in the artisan, including the turner, and on the basis of percentage of grade 1 artisan, and not existing prescribed percentage of artisan, the senior-most artisan and machinist trade and the turner are equal and are entitled to be promoted to the post of master craftsman whenever 2 posts are created, but the fact and circumstances showed that 3 posts of master craftsman were created, but the workman was not considered for promotion. From my above discussion and having heard both the sides and taking into consideration the decision of the Honorable Supreme Court, as mentioned above, it can safely be held that management has failed to implement the procedure for restructuring of the post in the event of redeployment of workmen in carriage and wagon department of the Lambing Division NFLA, and they were given the status of supernumerary post holders by creating special supernumerary posts for them, while the management ignoring the restructuring formula and other guidelines issued by the railway board from time to time, as discussed above, promoted the man from machinist grade to the post of master craftsman. Such an act was done by management in violation of the provision of Article 14 of the Constitution, as well as the principle of natural justice, as well as the rules and guidelines of railway board, causing grave irregularities and injustice to the workmen. As such, I am of the opinion that the workman Subhash Bonik would have been promoted as master craftsman, senior technician with effect from 1/1/2006. So, my lord, he retired, my lord, in 2007, my lord. He was, the direction was to give him, my lord, promotion from 1/1/2006. My lord,
No.
my lord.
So what is the error?
Error, my lord, I have shown, my lord, how the seniority position was drawn, my lord. And, my lord, what he,
If they are transferred,
my lord,
then as per your standing rules,
my lord,
you will have to give them full seniority.
my lord, amalgamated seniority, my lord.
No.
My lord, machinist,
You pointed out this
my lord, I have pointed out, my lord, kindly, lordship may kindly come to
page that
17, my lord,
rule
of the
7.
master circular, my lord.
Yes.
If only a small number of staff
Hmm.
are being rendered surplus and they have to be transferred to various units of other departments against vacancy, duly sanctioned posts, they can be suitably assessed in this rule with their full seniority and merging their seniority, my lord.
No. Before merging, you have to give them full seniority. Before merging,
My lord.
you will have to adjust them in the unit
My
with
lord,
full
in
seniority.
his trade, my lord, he is senior, my lord. There is no dispute, my lord.
No,
But
so
when, my lord, the amalgamation, my lord, it was merged, my lord. Machinist, turner, fitter are merged together, my lord. My lord, a person from the fitter or machinist, my lord, he becomes senior, my lord. So,
no,
my lord, H.G. Rabha becomes senior, my lord.
on what basis are you preparing a consolidated seniority. What is the yardstick for that consolidated seniority?
My lord, as per this master circular, my lord, the workmen of in various trades, which were, my lord, rendered third class, my lord, they were sent to mechanical department, mechanical department, and my lord, they were, my lord, all those persons were merged together, and my lord,
What is the meaning
combined
of-
seniority list was prepared, my lord.
I know what is the meaning of merging. Are they put below the existing persons?
Not existing person, my lord. What happened, my lord? I'll explain, my lord. Now, my lord, suppose there are three trades: machinist, fitter, machinist, and some other, my lord, two or three trades are there, my lord. Now, he is fitter, my lord. He is the senior most fitter. And, my lord, there,
No, turner.
sorry,
Correct.
turner. He is senior most turner, my lord. Suppose there is one person who is fitter. He is the senior most fitter, and another person who is, my lord, senior most machinist. So when, my lord, it was combined but together, my lord, we'll see the seniority of both these three persons, my lord. And whoever is senior, my lord, after merging, my lord, whoever senior, my lord, he will get the
Seniority from the date of entry.
yes, my lord.
And what was the finding of the tribunal here in this regard?
Said, my lord, three posts were, my lord, were vacant, my lord, and he is not giving this, my lord.
Oh.
The
Where is
finding,
the
my
where is the finding of the tribunal regarding
tribunal, my lord.
merging of seniority?
My lord, 18, my lord. 1 second, my lord. I would like to read, my lord. Para 18, my lord.
No, not
Para 18, my lord. S page 23, my lord.
here.
In the instant case, the rule of seniority and fixation of number of posts of master craftsmen, as well as promotion prescribed of the artisan, including the turner, and the basis of percentage of grade 1 artisan, and not existing prescribed percent of artisan. The senior most artisan and machinist trade and turner are equal and are entitled to promotion. So, my lord, that is not the case. They cannot be equal, man. The Honorable Court has held that all the senior person, my lord, in different trade are equally senior, man. Number one, my lord, and entitled to promotion to the post of master craftsman whenever two posts are created. My lord, again, it said that whenever two posts are created, my lord, the contention of the department is that there was only one post, my lord. And the fact and circumstances show that three posts of master craftsmen were created, my lord. My lord, if there are three posts, my lord, what prevented us from, my lord, giving him promotion, my lord? But the workman was not considered for promotion, my lord.
Take us to the evidence as reflected in the judgment.
My lord. My lord, my lord, Lordship may kindly come to page number 12, my lord. I would like to read para 3, 4, and 5, my lord.
What happened? Evidence so far start from era 6, page 14.
My lord, I would like to read, my lord, the previous two paras also, my lord, if your lordship kindly.
Yes, read.
Yes. My lord, I will start from para 3, my lord. Be it mentioned here that remaining 5 other workmen, Mr. N.G. Mitra, Sri Khagendra Singh, Sri Kaliram Borua, Sri H.G. Rabha, and Stopon Das, unreserved, appeared through their General Secretary and learned advocate and submitted written statement stating inter alia that Sri N.G. Mitra, Khagendra Singh, and Kaliram Borua were working at
Where are the evidence?
My lord, not where, my lord, this is not evidence, man.
Record?
Or record, my lord, probably records were
Record
No.
right there.
for
Like two evidence are there. If you para 6 your lordship,
Hmm.
6 started from the worker is para 6, then continued 1 by the management.
Malak, it was that
It is there, my lord. All the evidence is
evidence has been discussed here, Malak.
categorically disturbed. Let my learned friend finish.
May I start from then para 6, Malak. Malak,
Yes.
may I read, Malak. Para 6, Malak, at page 14, Malak. The workman examined two witnesses, including himself, while management examined Swapan Chakraborty, the head clerk, personnel branch, CPO office, NFRLA, Maligaon, Goa. Let me discuss the evidence of both sides. According to the workman Subhas Banik, he was appointed as Thalasi on 12/12/65. The NFRLA division headquarters Maligaon and deployed in wagon repairing shop at Pandu. Afterwards, he was promoted to Turner grade 2 from grade 3 on 1982, and thereafter Turner grade 1 on 28/10/1997 under the chief mechanical engineer Maligaon, and his contention is found to be admitted as it revealed from the WS submitted by the management. Subsequently, the establishment wagon repairing shop at Pandu was closed while W1 was deployed in the carriage wagon department of NF Railway. WW1 along with other surplus staff were kept separately, my lord, by creating supernumerary reports. This is important, my lord. And the establishment of those staff were maintained in the Office of Mechanical Section of the Chief Personnel Officer, NF Railway, Maligaon. Lastly, he served as technician grade 1 of Turner category under the Chief Mechanical Engineer, NF Railway, Maligaon, and he was the senior most technician and was fit to be promoted to senior technician. So, my lord, he was senior in, my lord, his grade only, in the scale of 5,000 to 8,000. The post of which was lying vacant since December 2005 under senior CDO Guwahati. The
What is-
WW1
what is
being the
WW1?
senior person.
What is
said,
WW1?
uh,
WW1?
uh,
Workman.
workman
witness number
workman witness. Yes, madam. Workman witness. Madam. He WW1 being the senior most person in the trade deserved to be promoted against the existing vacancy after ascend senior technician was retired, and his expectation to get promotion with effect from 1/1/2006. He could not be fulfilled by the management for unknown reason. Instead, H.G. Rabha machinist, my lord. He's the machinist, my lord. He was standard, he is machinist, my lord. Machinist grade 1 has been promoted as master craftsman in a slot which is against the provision of rule. He further stated that there cannot be any post of master craftsman in the machinist grade 1 according to railway rule. But for the purpose of promotion, machinist trade and turner trade was amalgamated, violating the rules, my lord. He said this is a violation, my lord, and also depriving him from his rightful expectation. While there was no impediment to promote the workman WW1 as per the provision of rule of management framed from time to time, further contention of WW1 is that as he was deprived of his due promotion because of wrong application of rule by adhering to the post-based roster, my lord, and he retired on superannuation on 39/2000, he is entitled to promotion to perform a promotion with effect from 1/1/2006. The 2006, my lord, superannuated, he was probably superannuated in 2007, my lord. 7 was missing, my lord, here. 1/1/2006 and get all financial benefits. In cross-examination, the WW1 categorically mentioned that his promotion was due on 1/1/2006, consequent upon retirement of SN Das on 31/12/2005, and thereafter Mr. Hareshwar Halai retired on superannuation in year 2005. And also his promotion was due, but he was not considered by the management. He also mentioned that H.G. Rabha was promoted in place of Hareshwar Haloi, who was a machinist. The workman WW1 categorically denied the suggestion tendered by the management that H.G. Rabha was promoted as grade 1 machinist in the year 1993, whereas he has got promotion as Turner in 1997. So, my lord, H.G. Rabha was senior, my lord. And that the Turner and the machinists were amalgamated together. And accordingly, the seniority was counted and promotion was done on the basis of seniority. He again mentioned that he did not know when H.G. Rabha joined his service, my lord. He denied, my lord, when. My lord, we have shown, my lord, when H.G. Rabha joined, my lord. Nor he had submitted any document to show that H.G. Rabha was junior to him. The workman witness number 2, Pradeep Kumar Saha, the Joint Secretary of Railway Mazdoor Union, Pandu, stated that initially the workman Subhash Banik was deployed in wagon repairing shop at Pandu, and afterwards he was promoted to Turner Grade 3 to Turner Grade 3 to Grade 2 in 1982, and then to Grade 1 on 28/10/1997. Due to closure of wagon repairing shop at Pandu, the workman was redeployed deployed in carriage and wagon repairing department in NF Railway, and workmen and other surplus staff were kept separately by creating supernumerary posts, and the establishment of those staff were maintained at the office of mechanical section of the chief personnel officer NF Railway Maligaon. The workman was the senior-most technician and was fit to be promoted to the senior technician in the pay scale of 5,000 to 8,000. And the post was vacant since 2005. In the event of retirement of S.N. Das, the senior technician, on 31/12/2005, my lord, he is claiming from 1/1/2006, my lord. S.N. Das was retired on 31/12/2005, when, my lord, the amalgamation was done, my lord, and, my lord, H.G. Rabha became senior, my lord. He also mentioned that instead of promoting the workman according to the rule, H.G. Rabha the machinist grade 1 has been promoted as master craftsman, and for this purpose of promotion, machinist trade and Turner trade were amalgamated. My lord, this is his, my lord, specific allegation that how can you amalgamate, my lord? This was amalgamated as per rule, my lord, master circular, violating the rule, my lord, and was deprived the workman from the rightful expectation. As such, the workman has been perennially deprived from his dues since 1993, including incorrect application of rule during the restructuring of cadre in his department under board scheme effective from 1/11/2003. Thus, the workman is entitled to promotion with effect from 1/1/2006 and to get the financial benefit, although he has retired. Management witness number 1 also produced a photocopy of the order dated 18/9/1996, marked Exhibit C under objection, wherein machinist and Turner grade were amalgamated. My lord, page 17, my lord, were amalgamated and combined, and next promotion would be senior technician, MCM, from the amalgamation combined list. She said that H.G. Rabha was rightly promoted in the next grade. She denied the suggestion tendered by the workman that there should be separate MCM from the respective machinist and Turner grade. So his, my lord, contention is that there should not be amalgamation. There should be 2 posts, my lord, for machinist and Turner, my lord. And, my lord, if, my lord, there are 2 posts, my lord, then he becomes the senior and got the promotion, my lord, would have got the promotion, my lord. And that the promotion of Subhash Banik was not considered on the retirement of Mr. S.N. Das. She also added that even if there is no amalgamation combined list, still H.G. Rabha was senior to Subhash Banik, and in normal course, he should get promotion. And that the workman, Subhash Banik, also did not file any objection before the authority that his promotion was not considered by the department in case of promotion of grade 1. In case of the promotion of grade 1. The cross-examination of MW1, management witness number 1, says that no new circular was issued by the management accepting the Exhibit C under objection in respect of amalgamation combined promotion to master craftsman. Regarding Turner and machinist, and the post of MCM was existent since 1987. She further said that she did not know whether the workman Subhash Banik got restructuring benefit, if any, but the workman got his usual promotion in the year 1997 as grade 1, and after amalgamation of the post, the Turner machinist, a combined seniority list was prepared, wherein Mr. R.G. Rabha was senior to Mr. Banik. In course of argument, Mr. M. Bora, learned advocate for the workman, submitted that the workman Subhash Banik was appointed as Khalasi on 12/12/1965, and he was promoted to the post of Turner Grade 3 on 19/7 and 1982, and from Turner Grade 3 to Grade 2 on 16/5/1988, and from Turner Grade 2 to Grade 1 on 28/10/1997, and the workman was redeployed along with other carriage and organ department of Landing Division NF Railway, and they were given the status of supernumerary post holder by creating special supernumerary post for them. As such, the workman was to be governed by the rules of seniority, promotion, and restructuring, upgradation of post, and other service conditions under rule concerning the special supernumerary post as per the rule formulated in the railway rule and master circular. My lord, this master circular was mentioned, my lord, issued by the railway board from time to time. In this contention, Mr. Bora, learned advocate for workmen, referred this standard book standard book. My lord, the second page was probably, my lord, Flossy may kindly see at the bottom, page 8, it is written. My lord, so my lord, some wrong in pagination, my lord. I'll get to, my lord, the next page, my lord, page 10, my lord. Railway rule, my lord, at page 19, my lord. Railway rule, an establishment by K.P. Sharma 2003 edition. Mr. M. Bora also relied upon the Railway Board Master Circular number 22/1 regarding provisions on supernumerary posts. 2. Railway Board Circular number so-and-so dated 14 to 1986 regarding introduction of posts of MCM. 3. Circular number so-and-so dated 27/1/1933 for restructuring certain Group C and Group D cadre, and the Railway Board letter dated 9/10/2003. Learned advocate for the workmen in the light of Railway Board Circular rule as mentioned above submitted that the supernumerary post is shadow post, and it can be created only if an order, if an other vacant permanent or temporary post.
Come to page para 14.
Para 14, my lord.
Page 22.
My lord, I'll come. My lord, page 22, my lord. The Railway Board in their circular dated 9/10/2003.
Where is this circular? Is
My
it available here?
My lord, it is dated 9/10/2003. My lord. This is not here, my lord.
Hmm?
Probably, my lord, in the record, my lord, it will be here, my lord.
Well, if your lordship permit me.
9/10. My lord,
Here.
my lord. So, my lord, if I read, my lord, para 14, Railway Board in their circular dated 9/10/2003 in para 2 made it clear that this said order is applicable to regular cadre excluding surplus and supernumerary posts of open line including workshop and production, and as such, the supernumerary post of Turner is also covered by this circular. The board also by circular number dated 76/2004 clarified that all supernumerary posts should be set off first before effecting the promotion from the lower grade to higher grade, and the required matching circular post on existing number of posts should be worked out, and the circular effected in such manner that the final cadre of the post result in specific percentage discrimination between grades.
Yes.
Malab, this is probably malab, number of malab, post of the malab, master craftsman malab. But malab, here malab, 2 posts were vacant malab. One was filled up in 2005 and one is filled up in 2006 malab. In both cases, my lord, what happened, my lord? After my lord drawing the my lord combined seniority list, my lord, HG Rava became senior, my lord, and there before that, my lord, HG Rava one Mr. Sarkar was promoted as SC candidate, my lord. My lord, that my lord order is also with me, my lord. My lord, may I read paragraph 15, my lord? This is clear from the above discussion that the management has not implemented the procedure for restructuring and maintaining the seniority as well as promotion to the higher grades of Turner artisan in the light of board circular dated 9/10/2003, dated 27/1/1993, and dated 14/2/1986 in respect of workmen, including the present workman Subhas Bani. And as such, I find no reason to enter in the argument raised by the learned advocate of the management. Learned advocate for the management put forward another argument that the relevant time there was only one post of master craftsman, senior taxi, and as Sri H.G. Rava belonged to the scheduled tribe category as well as the senior most machinist grade 1, and by promoting Sri H.G. Rava master craftsman is no way affect the legal life of the workman Subhas Bani, since the restructuring formula has not been applied by the management, and also there is no provision for reservation in case of single post, as revealed in the railway board letter number so-and-so dated 21/8/1997, Annexer 7, regarding model roster for cadre strength of direct recruitment and reservation roster of Group C and Group D post. Promotion category, this argument is also found not relevant in the instant case.
What is the meaning of set off? Para 14,
My lord.
there is a reference, there are references to two circulars, 9/10/2003
My lord.
and 17/6/2004.
My lord.
So as per 17/6/2004, supernumerary posts are to be set off. What is the meaning of set off?
My lord, regarding this circular, my lord, if you will also kindly give me time, my lord, by tomorrow, my lord, or my lord, by Monday, my lord, I will get the, my lord, lots of care can take it part out, my lord, keep it part out, my lord, by Monday, my lord.
What part? You are the appellant here, you are the petitioner here, you have to prepare your case and argue.
Set of word, my lord, that's what, my lord.
This is the whole crux of the matter, para 14.
My lord. But
14
my
and
lord,
15.
in para 15, my lord, it is categorically stated, my lord. And my lord, I have also the, my lord, how the seniority was, my lord.
See, the petition, the respondent was what? He was appointed in supernumerary post.
My lord.
Then he was amalgamated.
My lord. My lord, the roster, my lord, which my lord, calculating the seniority, my lord, even that roster is also with me, my lord. I can produce it before your lordship, my lord.
You should bring all these relevant record papers, what you require, by bringing it on record by way of an affidavit. Why are you producing papers like this in the hearing?
Yes, my lord.
Huh?
Yes, my lord. That's my fault, my lord.
You have come before the court.
My lord, actually, my lord,
that's a first ground to dismiss your petition. That your cases don't contain the relevant record.
Actually, my lord, lower court records could be, my lord, could have been annexed, my lord. My submission is
Need not be annexed, but we can call for it. Should have been called for it.
LCR, my lord.
Yes. Whether these records were placed before and who has placed it, all these things will have to be examined.
My lord, actually, my lord, this case was not filed by me, my lord, some other railway advocate actually. Subsequently, it was given to me.
Whatever it may be, if you think that there are corrections to be made, you should make it.
My lord, whether, my lord, may I pray for calling the LCR, my lord, my lord, if possible.
LCR आना है.
Last occasion,
and my lord, I have
on the other day, my lord, when your lordship asked the query method, learned counsel appearing on behalf of some. Not necessary. Now,
Malab,
well, everything is there.
I can show Malab, this is the Malab, WF file Malab. I took them Malab, it is not in the record Malab. I requested them and Malab, they have given me Malab, some of the documents Malab. This is the WF we have filed Malab. I have brought Malab, this document, but not, it is not in the record Malab. I must admit Malab.
No, we don't need the records for anything else other than understanding the basis of the conclusions by the labor court. That's all.
Malab. So Malab, my humble submission Malab, prayer Malab, LCR may be called Malab.
2021, the rule was issued.
My lord, 2015 matter.
Malab, he
Malab,
died, my
one
lord.
pointing, my
My lord, a lot of time spent on my lord substituting the legal hair, my lord.
My lord, it is.
You had appeared when the rule was issued.
Yes, my lord.
Then
LCR should have been called, my lord. I should have, my lord, informed the honorable court, my lord.
all right, let us hear him for a while. Yes.
My lord, first of all, my lord, may I please, your worship, my lord, making some correction of the my lord, taxable aspect. My lord, if your lordship, there is no illegality, irregularity, and perversity in the award. My lord, this reference came only when 6 persons, 5 others, and the workmen. Well, illegally was done. That is why this 6 person made a representation appeal before the management to overcome this irregularities. When nothing has been happened, my lord, they file a representation before the union, my lord, Ministry of Labor. That is why they are also not given the response from the management. That is why this reference came forwarded to the labor court. At the very first paragraph, my lord, one small paragraph. Reference has been initiated upon the order such and such 2008 issued by Ministry of Labour Employment, Government of India for adjudication of dispute between the management of the NF East Maligaon, Guwahati and the workmen Subhash Bonik and 5 others. The schedule of the reference is under whether the action of the management railway by denying promotion to the Subhash Bonik grade technician grade 1 Turner and 5 others as per annexure is legal and justify. If not, what relief they are entitled. And upon during this reference manner, before that manner, the workman retired 37,007. Now reference came after examining all this, judgment was passed in the year 2013, 2013.
What is your case?
No.
Right.
During pendency, the workman died, so legally they are a person. Now, these 5 men already retired, only the workman present reference. In the case of the workman matter, while my submitting my learned file matter, there are 3 categories. Feeder post is the completely different. This workman was initially appointed as a khalash. Thereafter, he was promoted to grade Turner. Feeder post is a then Turner 3, then 2, then Turner 1. When he promoted in the post of the Turner 1, his next post is to the senior technique mechanism, that is MCM. The other term is used, senior technique, master craftsman. So the workman's trade is the Turner. And the one H.G. Raba, who was promoted at that time, he is a masonist. Feeder post cadre is a different matter. That is why the Honorable Tribunal has held that the right for equality of Article 14 matter. He should have been promoted. He also should have been promoted. Only purpose of promoting this H.G. Rabha matter, this combined list was prepared. This is the illegality violating the railway circulars and railway board rule regulations guidelines. It is already observed in this, discussed in this award. Now I take a lordship as factual aspect, and I would like to read the entire judgment, my lord. If your lordship, it is clear, my lord. For a moment, my lord, just I'm reading 4-5 paragraphs.
So first tell us in a nutshell.
My lord.
Your case.
My case is my case. I ought to have been promoted in my cadre, my lord, as a
What is your cadre?
My lord, Turner grade 1.
You are already grade 1.
My lord.
Then after that, what is the next type?
And the post is the master craftsman. This is master MCM, master craftsman, senior technician. My zone is a different. And the H.G. Raba who was promoted, he was in the deferred state. He was initially appointment and his promotion was in the machinist method. That is why, my lord, if your lordship see the judgment para, my lord, 18, my lord. It is clear, my lord. Post was there, my lord. Instead of promoting me, my lord, they amalgamated a combined seniority.
What are you claiming?
My lord. MCM, senior technician.
You are grade 1.
My lord, grade 1 in the Turner grade.
Turner grade 1.
And H.G. Borua is a machinist grade.
All right. Now from Turner grade 1, what is the next higher post?
My lord, senior technician.
Senior technician.
Other name is MCM.
So
In
where under the rules do you find
my lord,
the description of these posts and
Mal.
the feeder category?
my lord.
Is there a
Yes,
set of rules?
my lord.
Yes.
My lord, I have the paper which is handed.
Yes.
If your lordship, my lord, the circular that is RBE number 13120/2004, my lord.
2004.
My lord, it is the higher grade is in the repetition is the
2004.
my lord. My lord,
17.6.
my lord.
Yes. Then
17/6/2004, my
yes.
lord.
What is the circular
My
number?
lord, that is
Circular number?
This is circular number is, my lord. That's it. Restructuring certain groups C and D cadres, my lord. My lord, what?
Yes.
Just a moment, your lordship asked for query. All the supernumerary posts should be set up first before effecting any promotion from the lower grade to the higher grade.
What is the meaning of that?
My lord, from the lower grade, that is grade 1 to higher grade, my lord, MC senior technician. My lord, first supernumerary post user grade, my lord, because of the closure of the Pandu, my lord, existing the wagon, my lord, this all the employees, my lord, giving the creating supernumerary post, including the workmen and others, one, my lord. So effecting the supernumerary post first from lower grade to upper, higher grade.
No.
These
You have
three,
to. What is the meaning of set
Malab,
off?
it is set up is to first deducting, giving the
Does
effect.
it mean no? Does it mean giving priority to those employees in the supernumerary,
Yes, madam.
or does it mean bringing them into the regular cater first?
Malad giving
You are into the supernumerary
Malad
post.
because of the otherwise
You were in X cater.
Malad.
You that particular office closed. So the obvious thing is that you will ordinarily you would have been unemployed.
Malad.
Instead of that, all the X cadres are brought into Y.
Malad.
Now the Y has a certain number of posts.
Malad.
Now, in order to accommodate these X cadres, these employees from X cater, certain posts are to be created, which are supernumerary. So you're absorbed there. Now,
Including others.
along with the others. Now tell us what is the meaning of set off.
Malad. First,
You are not a regular. You are not into the regular cater. You are brought by way of a supernumerary.
All are because of the
Whoever we are concerned with you now.
Malad.
So you are brought into a supernumerary.
Malad.
If you are a supernumerary,
in my cadre,
then once you vacate that post by way of promotion, retirement, death, whatever, that post goes.
No, my lord. SN, my lord. SN Das was there also, got the supernumerary my lord, privileges. He retired on 31st December 2004. Upon the returning of third, immediately being a senior grade 1, my lord, I ought to have been promoted.
These are things you are submitting without reference to
no, it is on the record. My lord, if your lordship kindly see this para, my lord, it is there, my lord. It is there. my lord, para page 15, my lord. Page 15, my lord.
Yes.
WW, my lord, in the middle portion, WW1 being
Why
the
are you now pursuing this matter after all these years? What benefit do you want?
my lord, only that is why I am, my lord, since during pendency of this writ petition, my lord, the workman died. Subsequently, they have been substituted the wife and the daughter. My lord.
Hmm.
Now, since before giving the award, my lord, I have already returned. Only financial benefits, so that, my lord, at the stage of ours of the wife also, my lord, will, my lord, maybe some get small amount, my lord, in the maybe pension, it will be increased. That much, my lord, because if your lordship kindly appreciate, because of their illegality, I mean, there is
You have
no,
to see, first thing you have to appreciate, you have to tell us why from 2015 you are allowing this matter to be pending before this court.
my lord,
You are claiming for
my
financial
lord,
benefit.
my lord, reading after the judgment, we made a representation. In the affidavit, you stated, even there is no stay order, madam. Even then, we make a representation, kindly consider the financial benefit. After the death of the workmen also, madam, they did not. In spite of the,
That is all right, but if you want the
there
benefits,
is no interim order.
then
Now, because of this illegality, my lord, the merger, small amount, whatever may be in the
whatever
increase
it
in
may
the,
be,
my
but
lord,
for 10
acting
years,
with
what were you doing? If you are asking for financial benefit,
Madam.
workman has expired, the legal years have been impeded.
My lord.
There is no urgency from your side found in the order sheets that you wanted an early hearing for the
My
10 years. Why did you allow the matter to linger on?
that is a manner, that aspect, my lord, I have to honestly submit, my lord, the council sets earlier, my lord. If that is some extent, my lord, I have just 6-7 months I entered, my lord. Anyway, even then, my lord, there is no interim order, my lord. They should have, my lord. I have visited there. We have visited now. Subsequently, the old lady, my lord, visit on several occasions, make a some
Yes,
revision
Mr.
done also.
Goswami, there is no interim order.
There is
Why the order has not been implemented? The labor court?
Yes, my lord.
my lord, these are the that man wife also, my lord.
You are duty bound to implement the order of the labor
They
court
receive also, my lord.
unless there is a stay.
Yes, my lord.
Kindly see. They even did not implement. They received. We have made a representative.
Don't give us copies like
Man,
this. We
man.
don't want.
Man, just
Give it back.
man.
You have filed petitions, whatever papers you think are relevant, bring it on
Man,
record.
man.
Don't give these loose papers.
Sorry, man.
There is no meaning.
So, Mala, there is no illegality and irregularity. Only right to equal, right protection, Mala.
No, that's what we are trying to understand.
Mala.
You are a supernumerary, you are a holder of a supernumerary post. You have been merged.
Man.
You are taking benefit of a clarification given in a circular
Man.
that it must be set off.
Man.
Your interpretation of set off is that you have to be given precedence in promotion. So what basis are you making this?
In my grade, Mala. Like HG
No, you don't have a grade. You have been merged.
My
No, all are marked. Even then, machinist, turner,
There is
artisans are
there is
three.
only one post, senior technician. Is the post is the higher post?
Three different category. Three different. 18 paragraph.
Uh,
Three, my lord. Two have been given. I have been left out, my lord. In the
these other two, what category do they belong?
one is artisan and another is machinist. I am trader. Turner.
And these posts which they are being given promotion to,
My lord.
what category do they belong to?
Well, they are different categories. I am turner, machinist, and artisan. 18, my lord. This is the case.
Is the higher post also earmarked in that manner?
All the categories are post.
From where do you say that?
Well, it is in the record maybe perhaps, my lord. 18 is there, my lord, paragraph. In the instant case, rule of seniority and fixation of number of posts of the craftsman, senior technician, as well as promotion to the prescribe of the artisan, including the turner, on the basis of the percentage grade 1, artisan, and not existing prescribed percentage of artisan, senior most artisan, machinist, and turner. All are equal, three categories. and they are entitled to promote to the post
Para,
of the
para,
master chef.
para.
18, madam. Page 23.
So where are the rules of seniority? Where are the rules of seniority?
My lord, seniority in the different categories according to their joining, according to their.
You are reading para 18.
My lord,
Para 18 refers to rules of seniority.
my lord.
Where are the rules
My
of
lord,
seniority?
these are all, my lord, in the circular. 4 circular is there, my lord. In fact, management has, my lord, pointed out these 4 circular.
So where is the percentage earmark?
My lord, it is discussed in the, my lord, page 21, my lord. No, my lord. Para 8, my lord, by the management. These 4 railway
But this is about promotion to the post of master craftsman.
master captains.
You mentioned senior technician.
No, same. These are 2 same. Well, it is in the senior technician and MCM are the same.
So
Rename.
what are the qualifications of this post? Master craftsman, what is the qualification?
Mala, this is promotional post from grade 1.
What is the eligibility criteria?
Mala, for that, mala, from the cadre post, mala, it is a.
On what basis are you saying that, Mr. Counselor?
Mala, for us, these 4 circulars in the record, mala, 4 circulars will, mala, reflect them same. Mala. That is circular, master circular number 22, 86 board circular, 93 MCM circular, and 2003
Third,
group C.
learned counsel to the party.
Since they have approached this,
This
management has, instead, they have to show in the repetition nothing.
the repetition is put to tell it, the judgment, the award dated 2003-2013, passed by the Central Government Industrial Tribunal, Labor Court, whereby the reference was allowed on contest in favor of the workmen, and it was observed that the respondent workman was entitled to promotion to the post of master craftsman within bracket senior technician with effect from 1/1/2006, with all benefits of pay and allowances, including pensionary benefits. So, there being agreed, the railways has approached this court to challenge this award. So, notice in the matter was issued as per package 6/5/2015. Subsequently, rule was issued on 11/1/2020. So, since then, the matter has been pending. Today, when the matter is called up, it is seen that the in order to decide this question, certain circulars and rules found to be referred to in the order in the award are not available in the PD. So, therefore, this court is of the considered view that since the relevant papers which were before the tribunal, including the evidence, have not been enclosed in the present petition, the tribunal records are required to be called for perusal of the perusal of the court. Accordingly, the registry is directed to requisition the tribunal records having contained case number 2020. Let the matter be listed upon receipt of the tribunal records.
The tribunal record reference case number 12.
Reference case number
12/2008.
12/2000.
from the industrial tribunal come labor court.
From industrial tribunal comes labor court. What could the file?
Page 11.
Yes.
Last. Next.
There is no fixing, it has to come. As and when it comes, it is come.
11.
Yes. Yes, Mr. Goswami.
Shifting of an Anganwadi center, Lordship. After shifting, the petitioner was absent in the new premise.
Not appears for the petitioner, called Mr. K.K. Goswami. Appears for the respondent. We'll just keep it aside for the time being. Let us bring anyone come. Yes. In terms of the earlier order, an opportunity was granted to the petitioner to file reply evidence. However, the same has not yet been filed as per the office note. Dated 7/3. Although the petitioner is not represented, while the respondents are represented by Mr. A. Moore, additional AG, some purely for the end of justice. Matter stands deferred to be listed next week. There is no affidavit filed in terms of the earlier order.
We have filed affidavit.
No, no,
Petitioner, yes.
there is an order permitting them
Yes,
to
yes.
file it. Next week.
Oblige.
Yes. Transfer on punishment.
Punishment and authority. They have already referred a decision of Supreme Court to Meswari. There is yet another decision of Division Bench of Patna High Court.
Yes, we have seen.
Wherein, Lordship,
Patna, okay. There is one from Chennai High Court, Madras.
yeah, one is from Madras High Court.
No judgment from our High Court.
No, we could not have it.
Yes.
Okay, several complaints were received, Lordship. That's why, Lordship, that's why the transfer order
So
was
you are
issued, Lordship.
entitled to transfer him
Okay.
as an incidence of service.
Lordship.
You are entitled to transfer him perhaps after initiating some proceeding.
Lordship, as per several complaints were received, Lordship,
But
without
was he put to
termination of
notice? Was he put
as a
to
lenient
notice?
view, Lordship, without termination his job, Lordship, the department has transferred to the
You
petitioner.
have to put him to notice.
Lordship.
So post notice was issued, Lordship.
Huh.
So post notice was issued, Lordship. So post was issued, Lordship. Where is the standard issue?
What do you say with regard to the judgment of the apex court? Have you got a copy?
No, Lordship.
Who appeared last time?
So far, Lordship, hearing the cause was issued in the subsequent offence due to his absence continuously. But in the earlier Lordship, it was not issued, Lordship. But I go through this judgment, Lordship. The judgment is justified.
We'll pass orders and
Yes.
heard and accompany to the party. Reserved. Yes, we'll pass order.
Sure. Lordship,
To able to.
Lordship, here in this case, Lordship, the leading advocate, P.C. Sutia, Lordship, additional senior government advocate of Assam, today, Lordship, suddenly he is facing some personal difficulties, some health issues, Lordship. I'll pick the matter tomorrow or day after tomorrow, any date, Lordship. He will apply, Lordship. Monday,
This is with regard to a challenge to the notification.
yes.
Where is the notification?
Lordship. Office memorandum, page 53, 21 May 2020.
Which particular clause? Certificate of disability.
Yes.
You are aggrieved by what? Certificate of disability.
And my lord, I want to argue, my lord, because there are so many cases, my lord. So, my lord, it is a case, my lord. The article
Let him begin his argument. You
Lordship, it can be.
may it please ask, my lord, fact, my lord. My lord, in this series, my lord, there are, my lord, there are 3 grade 4, my lord, post, and my lord, 15 grade 3 post. And my lord, I am relaying the fact, my lord, of item number 6, 7, 8, and my lord, item number 14. Item number 14 is slight different, my lord. He
item number 6 you are appearing.
is not appearing, my lord. I am relying on the fact, my lord. I will relay my. I will
You are not appearing in item 6.
appearing, my lord, appearing.
Huh.
I will point out the fact of item number 6, 8, and 14.
All right,
And-
let us
yes.
begin with
And
6
my lord,
first.
kindly point out, my lord, may I point out, my lord? Item 14. He was appointed, he was joined, and thereafter he terminated. So fact, like
Yes,
kindly see page 35.
35.
And so,
Okay.
yeah.
Yes.
Mr. This notification was issued on 14 August 2017. In pursuance of enactment of Right of Persons with Disabilities Act 2016 and in supersession of earlier notification by so dated so, the Governor of Assam is pleased to notify the Joint Director of Health Services of respective districts as certifying authority under Section 57, subsection 1 and 2 of the State Act for issue of certificate of disability within their local jurisdiction. Certifying authority shall follow the procedure for certification as laid down under Section 58, 1, 2, and 3 of the State Act and the relevant provisions of the rule thereon. Further, the Governor Assam is pleased to notify the Director of Health Services Assam as appellatory for appeals against a decision of certifying authority for issue of certificate of disability under Section 59, 1 and 2 of the Right of Person with Disability. Dr. Kindly see page 36. This certificate was issued, my lord. This certificate dated 10/1/2022. This is to certify that we have carefully examined Sri so-and-so, whose photograph is above, and we are satisfied that he is a case of blindness, his dimension not application. He has 40% permanent disability in relation to his both eyes as per guideline so-and-so. My lord, this petitioner is a one-eyed person. He has only one eye. This certificate, then thereafter, my lord, page 37, a UDID card was issued, my lord. This was also permanent UDID, my lord. 40%, my lord. Holding this certificate, my lord, he participated in the recruitment process. My lord, 38, Annex 3 is the advertisement. May I read that?
Don't read the whole advertisement. We
No,
don't
no,
need
not-
point out the relevant portion.
Yes, my lord. The act and in excess of the 2021 Act, my lord, Rule 2027, my lord. And kindly see the clause C. The present number of vacancies are tentative and details of the vacancies, including pay-based census, at least 1 year until agreement. Then clause 4, my lord, age relaxation. The applicant shall not be less than 18 years or more than 40 years of age as on so. The upper age limit is relaxable only as stipulated below, my lord. Subclause D, my lord, 10 years for persons with disability candidate, my lord. 10 years for person with disability, my lord. There is no discrimination.
You're reading from
My lord, clause 4.
10 years.
Yes, 10 years. This is important matter. 10 years for persons with disability.
Yes.
Then, my lord, clause 8, selection procedure. There shall be two parts of selection process, my lord. Written test, interview. Then second, scheme of examination shall be strictly as per the Assam Direct Censor Rule, amended censor. Then 3, my lord, the selected candidate will have to bring all the original testimonials, that is certificate of proof of age, caste certificate in case of reserved category candidate, educational qualification certificate, economically weaker section certificate, disability certificate in case of PWD candidate, and my lord, so, my lord, Rule 19 for verification. For verification at the time to be notified later on, comma, amongst others, my lord. This is important. For verification at the time to be notified later on and amongst others, my lord, and undertaking regards to fulfillment of the eligibility criteria has to be uploaded in the portal. Then other, my lord, 9, other criteria. 4, subclause 4, my lord. The preparation of merit list and the appointment shall be made strictly in adherence to the relevant provisions of the Assam Direct Recruitment Class 3 and Class 4 Analogous Post Rule 2019. And 5, my lord, in case of contradiction between environments in the advertisement and the Assam Rule Act, my lord, and the rule, rule, the latter shall prevail over. In this advertisement, my lord, kindly point out clause 4, A is, my lord, relaxation, and the clause 8, C, my lord, selected can all the selected candidates for verification of the certificate. In case of PWD, he has to produce the certificate. And then, my lord, annexure 4. Annexure 4 is the admit cut, my lord. If applied, my lord, kindly see the first, my lord, application number, then roll number, Sanjay Chauhan, then, my lord, category, my lord, general, my lord.
Yes.
Post applied, my lord. Both posts were applied, my lord, class 10 and read up to class 10 and SSLC, my lord. Both posts were applied. The written examination date was 21/8/22, my lord. Then your lordship, annexure 5, page 40. Admit card for interview. He qualified in the written examination, then issued a admit card for interview, my lord. In the admit card, my lord, kindly see the category, my lord, general. And Dibbang, persons with disability. Yes. Post applied for read up to class 8. He qualified in the written exam for class 8 post, my lord. Then date of interview 6/2/2023. After interview, my lord, provisional result was declared, my lord, page 41, my lord. The result, my lord, qualified for appointment. And, my lord, close to, my lord, in box, my lord, serial number 2, qualified for appointment below, my lord. The confirmation of the appointment is subject to verification of all academic qualifications, category certificate, and other eligibility criteria declared at the time of submission of application form by the concerned department. Then 3, my lord, in case of PWBD category, appointment shall be confirmed after medical examination and clearance received from medical board, my lord. My lord, medical examination. And it is what?
Yes.
Medical examination. Then, my lord, the result, posting result was, the department was allocated, my lord. The petitioner was allocated in the water resource department, my lord, and the post is, my lord, Khalas. Then, my lord, a notification was issued, my lord, by the Guwahati Medical College, my lord, principal come superintendent of college, my lord. May I read this notification, my lord? It is for all. It is for information of all concerned that the Medical Education and Research Department, Government of Assam, will hold medical re-verification for the benchmark disability of the successful PWD candidate of the grade 3 and grade 4 examination.
What is your grievance? You tell us in a nutshell, what is your grievance? What are you aggrieved about?
My lord. Here, my appointment was subject to medical examination.
Right.
And I have to appear for medical examination because suitability is one of the factors for eligibility of appointment. Suitability is one of the condition, my lord. And now this, I have to medical examination. They use here, my lord, the re-verification for benchmark disability, my lord. And in the, if your lordship, the grade 3 post, there are, my lord, successful candidate 234. And grade 4, my lord, successful candidate 482. If your lordship kindly see page minute 107, page 107, my lord. The vacancy details was subsequently, my lord, for grade 4, my lord.
Where is 107? There's no 107 here.
My lord, additional affidavit, my lord. I filed the additional affidavit.
Here. There is no additional affidavit. Affidavit in reply. Okay.
I have also filed an additional affidavit.
Sending it. Huh? There is no additional affidavit.
My lord, may I pass? Then I have filed some additional affidavit in 4 cases, my lord, bringing some document. My lord, page 107, my lord.
When was it filed?
My lord, it was
Did you
filed on,
file it?
yes, I have filed.
There is no indication here.
My lord, I have filed on, my lord.
It's
25/4/2024.
not here. You give the title.
6 January.
Huh?
6 January.
Huh?
6 January.
Yes. So anyway, what do you want to show from here?
My lord, the vacancy details, my lord.
What are you aggrieved?
My lord,
What are your prayers in the writ petition?
yes. My lord,
You are
So, Lord,
seeking for setting aside of the medical opinions.
no, my lord, and OM, my lord.
Come to prayer number A, page
A-
30.
A and B, my lord.
Yes.
B, my lord, natural Saturday, not to be issued to select cost office member.
What is the ground for this? What is the ground that you are urging for setting aside?
Yes, my lord. Because, my lord, then I was, now, my lord, after, my lord, my selection, my lord. As per the rule, I am eligible for appointment, my lord.
Which rule?
2020 rule, my lord.
Where are the rules?
My lord,
Where are the rules?
I have submitted, my lord. Because, my lord,
Assam direct recruit,
yes,
class 2 and 3, 3 and 4.
yes.
Rule number?
Rule, my lord, 15.3. Rule 15.3. Appointment, my lord. See, my lord. No person shall be eligible for appointment to the service. Census sub clause D, my lord, if he is otherwise found not suitable.
Hmm.
Only I have to, in medical examination, I have to prove, my lord, whether I am suitable or not.
So,
But, my
what
lord,
is the illegality if they want to check your disability? You are claiming it under that category.
yes,
You are claiming this appointment in the category of a disabled person.
yes.
During the medical examination, if there is a attempt to examine or reassess
Yes.
your disability, these are public appointments.
Yes.
Where is the illegality?
My lord, illegality, my lord, if your lordship see the 2016 Act,
Here, let
My
us
lord.
see.
Alright, we have to understand this schema because this act has been come after repealing my lord because and my lord, what is the
That's what I'm asking you to make the
Yes.
court understand.
Yes, my
You point out to the relevant rule or act
not
or the section.
my lord. The purpose
Hmm.
why my lord benchmark disability has been introduced in the act, we have to establish that aspect, my lord.
What is the purpose?
My lord. There is a employment, my lord. There is a provision for employment, my lord. There are two. There is a difference, my lord. One employment is under a scheme framed by the state government, and another employment is defined as a public service, my lord. And they can reassess, my lord. Clinical reassessment can be permissible in the scheme if the government frame a scheme for appointment. It is different aspect, my lord. And if, my lord, it is a public service, my lord, appointment, my lord, in open category direct recruitment, in competition, my lord, then under this act, my lord, they cannot discriminate on the ground of disability, my lord. May I read, my lord? This act, my lord.
Yes.
First, may I read, my lord, definition, my lord.
Yes.
Section 2. Section 2, first S, my lord.
Yes.
Person with disability, my lord,
Hmm.
means a person with long-term physical, mental, intellectual, or sensory impairment which, in interaction with barriers, hinders his full and effective participation in society equally with others. And, my lord, the barrier has been defined at C, my lord, clause C.
Hmm.
Barrier means any factor including communicational, cultural, economic, environmental, institutional, political, social, attitudinal, or structural factors which hampers the full and effective participation of persons with disability in society. Then, my lord, the persons with benchmark disability. Person with benchmark disability means a person with not less than 40% of a specified disability, where a specified disability has not been defined in measurable terms, and includes a person with disability where a specified disability has been defined in measurable terms as certified by the certifying authority. As certified by the certifying authority. Not by the medical authority. In earlier, my lord, act, my lord, if you lordship see the definition of the benchmark, person with benchmark disability, there is a shifting of the concept itself, my lord. May I?
Yes.
I may not be. May I? The concept of shifting, my lord. That
We have this act, 95 Act.
Yes.
You're referring to 95 Act.
Yes.
We have this act.
Yes. And
Yes.
no, no.
Judgment.
My lord,
The judgment.
the term has been used, my lord. I may not in proper language, my lord. What is the shifting, my lord? Paragraph 45 and 46, my lord.
Yes.
The 2016 RPWD Act, paragraph 45. The 2016 RPWD Act was a landmark legislation which repealed the 1991 Act and brought Indian legislation on disability in line with United Nations Convention on Right of Persons with Disabilities. Under the old regime, my lord, disability was simply characterized as a medical condition devoid of any understanding of how disability is produced by social structure that cater to able-bodied person and hamper and deny equal participation of person with disability in society. Section 2T of the 1995 Act define a person with disability in the following terms. Person with disability means a person suffering from not less than 40% of any disability as certified by a medical authority. The Statutory Act has more inclusive definition of person with disability, evidencing a shifting from stigmatizing medical model of disability under the 1995 Act to a social model of disability which recognizes that it is the social and physical constraints that are at the heart of exclusion of persons with disabilities from full and effective participation in society. Like this is the shifting of the concept, my lord.
Yes.
And my lord, in fellowship C, my lord. Now the my lord, there are another category of persons, my lord, that is T, my lord. Section T, my lord, subclause T, my lord. To definite T, person with disability having high support need means a person with benchmark disability certified under clause A of subsection 2 of section 58 who needs high support, my lord.
This is not applicable in your case.
My lord, because why the benchmark concept has been, this is required, my lord. And my lord, high support has been defined, my lord, L, my lord. L, high support.
Yes.
High support means an intensive support, physical, psychological, and otherwise, which may be required by a person with benchmark disabilities of daily activities to take independent and informed decision to access facilities and participating in all areas of life, including education, employment, family and community life, and treatment and therapy, my lord, employment. And now, my lord, this employment is also an employment, my lord. And my lord, kindly see X. Proceed X.
Huh?
X, my lord.
X.
X.
Yeah. Yeah.
Public facilities and services. Includes all forms of delivery of services to the public at large, including housing, educational and vocational trainings, employment, and career advancement, shopping or marketing religious contents. Here is also the employment, my lord.
So from all this, what do you want to show?
My lord, actually for employment, if some benchmark persons are there, my lord, they can apply for employment to an authority appointed by the government.
Who can apply?
PWD, my lord, with benchmark disability. And subject to, there has been a scheme promoted by the state appropriate government, state government. On that process, my lord, on that specific purpose, my lord, benchmark concept has been introduced, and also, my lord, for reservation in the
benchmark was there earlier. It was certified by a medical doctor that this person suffers from disability. Now
Yes.
this has been shifted and brought to include, make it little wider.
Yes.
And therefore, these authorities which are notified are to give the certificate
My lord,
in terms of that
my lord,
UN convention.
my lord, once my lord certificate is issued, my lord, by a statutory authority, my lord, there is a provision for appeal. And under that certificate, my lord, one is entitled to apply for facilities, which is public facility.
Let us see that provision. Let us see.
Yes.
What was that provision?
Before, my lord, what I am pointing out to my lord, the one is, my lord, if someone has the certificate, he is eligible for appointment under a scheme framed by the government. And one is the certificate who is entitled for employment. These two difference. Eligibility, he become eligible, and in other, my lord,
What from the provision?
yes, my lord, the section 38. Because if we don't understand this, my lord, I can.
No, I'm trying my best to understand. But
Yes.
you have to follow it in a proper process. You are jumping from judgment to provisions. Submit as seriatim.
Lordship, before discussing all these things, I would like to inform some material fact here in this case. Lordship. In WPC 2991, Lordship, 2024, Lordship, same type of the same similarly situated case that was dismissed by the coordinate bench. Accordingly, they preferred an appeal, Lordship. An appeal was not appeal was withdrawn and subsequently withdrawn, and review again review was filed, and now the review is pending before the coordinate bench.
My lord.
Yes,
Then,
Lordship.
my lord, one thing I pointed, but if my lord,
What's the judgment?
I have submitted my lord already. That is the parent because I have said, my lord, because the provision has been not considered, and relying on a judgment,
The judgment has been recalled.
not.
No, Lordship. Only notice. Notice was issued. No,
Kindly bear my,
there is no stay order.
my lord, the arbitrariness, my lord, if I say, my lord, we are selected candidate, my lord. By exercising this, my lord, they want to make equal. They want to make my lord, equals as unequals by saying that at the time of certification,
Why
they
don't
were
you,
unequal.
why don't you submit in a manner that we can understand? I know that you have more ways of expressing it. But before we go to equals, unequals, we explain the provisions of the Act.
Yes,
Tell us
that
in what particular section is applicable to you and how it has been interpreted and why you are aggrieved. That's what we have been asking you for the past half an hour. You're
Yes,
wasting
yes.
a lot of time.
yes, my lord. Then you should, my lord, kindly see the certificate.
This is not a television program going on explaining the details of Disability Act. You are before the court. You have come. We did
Yes.
not invite you. Show us the provision.
My lord, certificate of disability.
Yes.
Section 57, my lord.
Hmm.
Designation of certifying authorities, my lord. That is by notification, my lord. Procedure for certificate. Any person with a specified disability may apply in such manner as may be prescribed by the central government to a certifying authority having jurisdiction for issuing of a certificate of disability on receipt of an application under such so, my lord, issue a certificate of disability to such person in such form as may be prescribed by central government and inform him in writing that he has no specified disability. The certificate of disability issued under this section shall be valid across the country. And section 59. Appeal against a decision of certifying authority. Any aggrieved with decision of the certifying authority may appeal against such decision within a time in such manner as may be prescribed by the state government to such appellate authority as the state government may issue. Well, unless and until, my lord, that decision is hold the field, my lord, or cancel, my lord.
Nobody is cancelling it. Is it a case that the state government is taking an exercise for cancelling the certificate issued by a designated authority? No.
Even that was also taken, my lord.
Huh?
Yes, notification has been issued,
Where?
my lord, at page
Wait.
my lord, page 58. Two, my lord.
Yes.
Medical board shall apply
You read the
duly.
whole circular. Read the whole circular.
In continuation of the department's previous notification that is
Where is that notification, earlier notification?
that is not here matter. Regarding verification and reassessment disability of person holding certificate UTID issued by certifying authority prescribed under Section 57 of the Right of Person with Disability Act, the following measures are further put in place in order to streamline the reassessment process of stakeholders, including the candidates appearing for the various recruitment examination under the government order against post reserved for person with benchmark disability.
Where is that circular, Mr. Goswami?
Lordship.
Medical board, who is there for Department of Health and Family? Come to page number 58. There is a reference of an earlier circular. Where is that circular?
If it has not been annexed there, Lordship.
And even, my lord, if my disability can assess, my lord, that is, my lord, by a medical board prescribed by the central government, my lord. That is in Section 38 is there. If I apply for a scheme, employment under a scheme, my lord. That is the difference. There is a reservation for all PWD, my lord.
Where is the definition of an assessment board?
My lord, that assessment board is not defined, my lord. If your lordship kindly see, my lord, page Section 38. That's why, my lord, I am pointing out that aspect.
Yes.
Section 38, my lord.
This is in respect of a person in need of high support.
Yes, that's the employment. It's same under the scheme, my lord.
No. Are you a person with disability in need of high support?
No.
Then?
No. Even in this, if I approach the government, I am the benchmark disability.
Why don't you read these provisions of the section? It doesn't apply to any other disability.
Yes, because under these, my lord, they can reassess, my lord.
No. They can reassess to find out whether you are a person with disability with high support. In
Yes,
need of high
benchmark.
support.
Means benchmark.
Of course, benchmark, but
Yes.
with high support.
That is, my lord, if your lordship can see page 52A, Rule 14A. Rule 14A. Rule 14A, my lord, page 52A, my lord.
14?
14A. A state government on union territory shall notify the authority to whom a person with benchmark district can apply for high support requirements.
This is again for high support.
Yes, my lord. That is one of the employment. High support means also one of the employment. Then, my lord, they can assess, my lord. Then only person benchmark having permanent certificate of disability shall eligible to apply for high support requirement. They shall constitute assessment board at district level based on number of personal benchmark disability.
This is applicable for disabilities with high support.
Yes.
You don't fall into that category.
I am following the direct recruitment.
Yes.
And that is
No, not direct recruitment. You claim to be a person with disability.
Yes.
Benchmark disability.
Yes.
You tell us from the act and the rules and the circular or the judgments that the state government under the statute is denuded of powers of establishing a medical board. That is your ground.
Yes.
Point out.
My lord, my certificate holding the field, there is no appeal.
Who is to appeal? It is for a person, if you are denied the certificate, you can appeal.
Yes. And then, my lord, section 20, my lord, in employment, kindly see. Non-discrimination.
Say you have no case. We'll have to dismiss your case.
Only
No, we'll dismiss it.
My lord, kindly see.
You are wasting enough time.
My lord, kindly see one judgment, my lord. The already held, my lord. And my lord.
Yes. What is the judgment about?
My lord,
See, I have, no, listen to the court,
reassessment.
listen to the court
Reassess-
first. You listen to the court. When you are coming before the court for a hearing, please give a list of judgments that you want to rely on.
Yeah.
This is no manner of conducting a hearing by producing one judgment from your file and giving another to in support of your judgment. You have to share the list to the other side also, and this applies to the respondent. You furnish a list first. What judgments you want to rely on? The reason we are explaining is the judgments that you're trying to rely on, we may not record in your judgment if we don't find it in the list.
Then, my lord, kindly see the section, my lord, the reservation.
Whatever your case is, you have to project and place it before the court. Yes.
Reservation. Section 30, identification and reservation.
Section
33 and 30.
we are asking you a pointed query, you are unable to give us the answer. Your
My-
grievance is that the state government is denuded of powers of reassessment once a certificate is issued. That is your case.
Yes.
Show us from the provisions of the Act.
Because, my lord,
Not because you show us from the Act that there is a specific provision. Under this provision, only this authority is required to give a certificate, no further assessment. That's your case. Point out.
in Bikesh Kumar case also, my lord, it was held. If accept the certificate, my lord, further
Where is
examination is not permissible.
Which case?
I have, my lord, Bikesh Kumar, my lord, I have submitted that document, my lord.
Do you have a copy of the judgment with you?
Hello?
Do you have a copy of this judgment with you now?
Yes.
Give us that copy. Let us see.
Bikesh Kumar judgment, I have
Vikas Kumar.
2001 5 STC, my lord.
Yes. Which paragraph?
Paragraph 77, my lord.
Yes.
The assistant argument that the appellant must be subjected to further medical examination, even though his disability has been accepted, is emblematic of a key barrier that often comes in the way of the disabled being able to access reasonable accommodation in India. As the Statutory Committee observed in its concluding observation on India, that the competent authorities must ensure that the multiple assessments as to the existence of disability do not create an undue burden for appellant.
Hmm.
And then, my lord, the party contending that a particular accommodation will impose a disproportionate or undue burden has to prove the same. And, my lord, therefore, I have submitted that judgment, my lord, Omkar Singh Gond, my lord.
See, you are now referring to one paragraph here, one paragraph there. You have to connect this with
Yes.
whatever case you are trying to project.
My lord, reasonable accommodation, my lord.
What is reasonable accommodation?
Reasonable accommodation is a facilitator to obtain the substantive equality, my lord.
Hmm.
Reasonable accommodation has been defined in the Act, my lord. And, my lord, kindly see the definition of discrimination, my lord.
Where is reasonable accommodation?
My lord, first say H, my lord. Section 2H.
2Y. Let us come to 2Y.
2Y, reasonable accommodation, means necessary and appropriate modification and adjustment without imposing a disproportionate or undue burden in a particular case to ensure to person with disabilities the enjoyment or exercise of rights equally with others.
Hmm.
And can you see discrimination? H.
Yes.
Discrimination in relation to disability means any distinction, exclusion, restriction on the basis of disability, which is the purpose or effect of impairing, nullifying the recognition, enjoyment, or exercise on an equal basis with others of all human rights and fundamental freedom in political, economic, social, cultural, civil, or any other field, and include all forms of discrimination, all forms of discrimination, and denial of reasonable accommodation. My lord, on this reasonable accommodation, my lord, the Omkar Singh Gond, my lord, that is 2024 10 SCC, 10 SCR, my lord, in respect of section 32 on the principle of reasonable accommodation, my lord, regarding the assessment board. Right, my
Paragraph. Paragraph.
paragraph, my lord, 46. Even this is in respect of, my lord, admission in medical college.
Hmm.
46.
Yes.
Disabilities assessment board are not monotonous automation to just look at the quantified benchmark disability as set out in the certificate of disability and cast aside the candidate. Such an approach would be antithetical to Article 14 and Article 21 and all canons of justice, equity, and good conscience. It will also defeat the salutary objectives of the RPWD Act. The Disability Assessment Board are obliged to examine the further question as to whether the candidate, in the opinion of the expert in the field, is eligible to pursue the course, or in other words, whether the disability will or will not come in the way of the candidate pursuing the course in question.
How is this relevant here?
My lord, here, my lord, my suitability, my lord.
Where is your suitability letter? Where is the disability certificate in your case?
And in vacancy details, my post has been shown as that as the reserve post, my lord. Certificate 36. And I have been only, my lord, in the opinion, my lord, medical opinion, there is no other ground. Only I have 30%, therefore I have been. But here, page 52, my lord, the opinion, there is no about that I could, there is no, my lord, anything, my lord, comment that I could not perform my job, my lord.
Now, where is the medical certificate, medical report by the state, page number?
52.
50. Yes.
52. As per this honorable court, my lord, direction, this was given, my lord. Disability status 30%. Category blind and low vision, my lord. Only on the ground of, my lord, that. When the act given the right to the PWD, my lord, on this ground, my lord, when there shall not be any dispute on the ground of disability, my lord, on this ground I have been thrown out, my lord.
Where is that disability status? Where is the disability status?
Disability status, my lord, disability is 6, my lord, page 52, clause 6, my lord. Disability status given in second medical examination appeal held on so 30%.
And what was the direction in 7297?
My lord, kindly see, my lord, page 47, my lord. Page 47, relevant, my lord, 49, and relevant question 50, my lord. By producing a copy of office memorandum, my lord. By
Page
producing
number, page number.
page 50.
Hmm.
By producing, my lord, first, third paragraph, my lord. By producing a copy of the office memorandum, sense of estimated sense of close 5 minutes under additional reason of the disability competent mechanism, hence the exercise. After hearing the learned counsel, this court finds that although all the petitioners are holding certificate which project them as candidates suffering from benchmark disability, yet it appears that as per the opinion of the special constituted medical board, the disability of the returner have been found to be less than the benchmark disability criteria of 40% disability. There may be cases where the extent of disability of some candidates were undergone changes in since issuance of the disability certificate, or there was some error in assessing their disability status either by the original authority issuing the certificate or especially concerning medical board. However, the said aspect of the matter cannot be gone into by this court unless the petitioners are communicated with the decision of the authorities in this regard, thereby giving them an opportunity to assail the such decision on merit if so advised. As such, without expressing any opinion on the stand of the learned counsel, finding and observation of the medical board, these decisions are being disposed of by directing the respondent to communicate the decision of the authorities pertaining to the individual disability status vis-a-vis their claim for appointment of each of the petitioners against the post applied for in writing within 4 weeks from the date of receipt of the certificate of this order. Liberty is granted to petitioner to assign such decision of the medical board and or the Department of Social Justice. Even the decision rejection my claim, my lord, that has not been given. When, my lord, under the rules, my lord, appointment for eligibility for appointment, my lord, suitability.
What is the parameters under which your certificate was initially issued by the at page number?
My lord, guideline, my lord, there is a guideline
Guideline.
issued by the central government.
Where is that guideline?
My lord, even that guideline also, my lord, only one copy.
Yes.
And my lord, under that, my lord, I have
Your guideline, do you have a copy of the guideline with you?
No.
This guideline says disability category, you fall in disability category 2, where the disability percentage is shown to be 30%.
But I have the disability in both eyes, my lord. Because one is I have one-eyed person, my lord, and
Hmm.
in other eye, my lord, there is
See, it shows only one-eyed person.
Yes.
One-eyed person means the
Yes.
other eye is not there,
Yes.
not working.
Yes. Then this
That
only,
makes you the disability.
my lord,
That makes you a disabled person.
my lord, then percentage, my lord, even percentage 30% will get if one had lost, my lord. And there is a percentage if in other eyes, my lord, there is some deficiency, my lord, then some more percentage is added, my lord.
So what is the meaning of one-eyed person? How do you define a one-eyed person?
This is real negative, my lord. In one eye, my lord, he does not see or
Exactly.
yes,
Therefore, you are a one-eyed person.
yes.
So where is the question of getting increasing your percentage in the other eye? That it is because of the disability in one eye that you are treated to be a one-eyed person.
Yes.
And therefore, your disability under these guidelines is assessed to be 30%.
No, then here kindly see the 30%, my lord, one eye. Then 40% will be, my lord, visual acuity in other eye, my lord. Six, six, my lord, next year, my lord. 6 by 24 to 620, my lord. Then 40% three category low vision.
Where is the medical report in so far as your eye examination is concerned? While giving you the certificate at page 30,
And my lord, in that, my and another aspect, my lord.
no, page 36, you are given a disability certificate.
Yes,
What is the finding here? This is the certificate.
yes.
Certificate is based on some medical examination.
My lord, he has 40% permanent disability in relation to his both eyes. As per guideline, my lord, that guideline, both eyes.
Where is that guideline? You say that it is your claim that with one eye there is no vision, there is no light perception. In one eye there is no light perception, means you cannot see. So
Because
that makes you
because
one-eyed person.
because this certificate has been issued, my lord, after a thorough medical examination, my lord.
That's what we are asking you. Thorough medical examination. Where are the medical findings
This
in regard to you? In regard to your examination, prior to issuing the disability certificate, where are the medical findings to say that these findings are in tune with the guidelines issued by the central government?
that is, my lord, that is the that is
A bare perusal of these guidelines reveals that for the disability that you profess, that you claim, the percentage of impairment is 30%, not 45, not 40%, 30%.
my lord, that is one aspect, my lord. Even I am a disabled, my lord.
Hey, you are a disabled, okay, but there is a percentage set
Yes. Whether, my lord, the
that makes
reservation
it a benchmark disability.
now, my lord, question is, my lord, whether the reservation for PWD, my lord, under the Article 16(1), my lord. And my lord,
No, we are not going here and there. You come to your prayers. Your prayers are very specific.
yes,
You want this interference with the opinion of the medical board, and you want interference with the office memorandum.
and office member, then kindly on I am on the office member.
Then where is the bar?
Yes.
As per the certificate on which you claim to be a disabled person with 40% benchmark disability, when the very guidelines prima facie shows that you have less than benchmark disability.
Then, my lord, on OMI,
OM.
my lord, and my lord, kindly, one aspect, my lord.
You can question the OM,
Yes.
provided you satisfy the court that your certificate at page 36 is issued after following the guidelines given by the central government.
Yes, my lord. In certificate issue that followed, my lord.
That
in
is, mere statement will not do. You have to refer it to the guidelines and tell us that this is how you are assessed to be 40%.
in even if, my lord, there is any discrepancy, there is a appellate authority, my lord.
So appellate authority, you go and file an appeal.
No,
You
there is,
go
if
and
there
file
is
an appeal.
discrepancy, my lord, Director General of Health Services India, my lord, he is the authority, my lord. And, my lord, even if, my lord, whether my Article 21 is not violated, my lord,
How?
my dignity has been lowered down, my lord, under the reasonable accommodation, my lord.
How your dignity is lowered?
I have been selected, my lord.
You have been selected because you profess to be 40% disabled person.
And, my lord,
Where is the subsequent medical examination? Is it here?
that is the subsequent, my lord. That is this, my lord. Page 52. This is the if that be so, my lord, then, my lord, there is no reservation for the PWD, my lord, only for benchmark. And
Where's the order of the High Court again? Earlier order.
then, my lord, in, my lord, Ramanlal Keshav Soni's case, my lord, there has been all exclusion, my lord.
See, the argument you're making now that the state does not have the power is your
Yes.
argument.
Yes.
State does not have the power to constitute the board.
Yeah.
once the disability certificate is given, is an argument you should have made in the earlier proceeding.
Yes.
Earlier proceeding also was the case where you had been subjected to the medical board, special medical board, and the court returned a finding or a view that there may be cases where the extent of disability of some candidates may have undergone some change. And therefore, you were directed to communicate the decision of the authorities by giving them an opportunity to assail the decision.
And that is, my lord, that is, we have to understand the reasonable accommodation. What is reasonable accommodation?
Whatever you wanted to argue, you should have argued
Yes,
in this petition.
my lord, even my lord, my lord, in the OM, my lord, they
Where are the medical reports? Where are they?
already furnished the petition subsequent to that order,
No, no, no.
this
but
is
not in this writ petition.
You have furnished
Yes,
the
sir.
finding.
Yes, sir.
this is only
Everything.
furnished. This page.
He says only this final result.
Lordship, the order of
52,
the,
this is a
52, he says only 52.
but there is no contempt petition to that, Lordship, because the order was very clear and we have furnished, Lordship. In other cases, Lordship, also we have furnished. There are series.
What's the copy? What's the copy you have? What document you have?
Yes,
my lord,
Lordship, I can furnish.
What's the copy?
Not right now, Lordship, but we have communicated. The reports were communicated from the GMC.
We want to just have a look at what was the finding arrived at in the report.
Yes.
You get it by 2 p.m. No.
Today, Lordship, might be difficult, Lordship. I can get it on Tuesday, Lordship.
my lord, my lord,
And I can give the list in
my
which
lord,
matters, Lordship.
close 5, my lord,
Hmm?
close 5, my lord, OM, my lord, they have made a law, my lord.
See, they have made a law, but you were before the court.
Yeah.
Earlier. You had abandoned the challenge. Court has disposed of the writ petition. CPC specifically may not be applicable, but principles are applicable.
But my lord, so now the reasonable accommodation.
Hmm?
Some reasonable accommodation.
What reasonable accommodation?
This reasonable accommodation, the principle of reasonable accommodation, my lord. Even in my lord, I submitted a my lord, in examination, my lord, there Supreme Court held, my lord.
We'll come to Supreme Court, High Court later.
Gulshan
You tell us from the facts, what documents have you got?
my lord, the PWD and PWBD
Hmm.
all are entitled all the benefits which are available for the examination matter in all examination. There is no distinction PW and PW.
You participated in that advertisement, didn't you? You applied for that advertisement.
Yes.
That advertisement has given a benchmark disability of 40%.
Yes.
You knew it.
Yes.
You have not challenged the advertisement to say that below 40 also, if you don't give us, it's violative of the provisions of the Act.
Because my lord, if your lordship, my lord, kindly see the benchmark,
Hmm.
the reservation in what is the criteria for reservation followed, my lord? Horizontal, overall horizontal
Whatever
reservation.
it may be, it was advertised. It was disclosed that it will be 40% benchmark. You apply for it.
My lord, this is not my fault, my lord. I am disabled, entitled for the protection of the Act, my lord. If your lordship kindly see, my lord, the reservation. What is the reservation, my lord? Section 33, my lord.
We can't allow you to go and expanding your case. You had come before the court earlier.
Yeah.
Petition is not here. We don't know what prayers you got. With the earlier petition, no. But from the order, it appears that court did not go into the merit and directed.
And my lord, my grievance was, my lord, it is not permissible to assessment. Earlier requisition in this recorded, my lord, that it was not permissible to assessment.
Permissible to assess what?
the disability.
That was not answered by the court. You did not file an appeal already. Why should we
He
entertain
preferred a
Review,
review.
Lordship.
He
Huh?
preferred an appeal.
Preferred an appeal,
Withdraw.
they subsequently withdraw. Lordship.
review is
and now the review is pending. Lordship.
review against which order?
Yes, Lordship,
No, no,
order
not-
dated.
No, no, we are referring to this order
1812.
judgment date 1812.
No, that has happened.
1812 to
In
20.
these cases, he has not prepared any appeal. In the cases that dismissed by Honorable Justice Surana,
Student.
He has
on
preferred
those
an appeal.
6 cases, he has prepared appeal, withdrawn, and review is pending.
Who has preferred?
Same
Lordship,
petition.
Same
same-
Petitioner. Yes.
My lord,
Petitioner has
Yes.
preferred an
my lord, after this judgment, my lord, this order, my lord, only the status has been given.
No concept.
That will be.
Have you shown to us that in the earlier writ petition, these prayers were not made, and therefore you have to come before the court for the second time? You had abandoned your argument, the claims there in the earlier writ petition.
But either there the liberty is given to assail the decision of the medical board
You
and-
assail it. You
and
assail it on
and
what
by-
grounds?
or the Department of Social Justice, my
You assail it, but not by expanding the scope. Why should we permit you to do that? There is no explanation why you did not pursue your claims when you approached the court earlier.
My lord, even if my lord, then my lord, that the concept of reasonable accommodation comes, my lord, when my lord, PWD, my lord, on the ground of disability cannot be, my lord, because it will be violation of Article 14 and 16 and 21. my lord.
May I be referring to the articles which not about violation. You have to show what is your right under the Act
Yes,
and,
my lord.
and how you have been deprived.
In the act, my lord, kindly see the rights, my lord. Section 3. Section 3. Equality and non-discrimination matter. Appropriate government shall ensure that the person with disability enjoy the right to equality, life with dignity, and respect for his or her integrity equally with others. The appropriate government shall take steps to utilize the capacity of person with disability by providing appropriate environment. No person with disability shall be discriminated on the ground of disability unless it is shown that the impugned action omission is a appropriate means of achieving legitimate aim. The appropriate government shall take necessary steps to ensure reasonable accommodation for persons with disability. Then, my lord, can you see Rule 3, my lord? Rule 3. The head of the establishment shall ensure that the provisions of subsection 3 of section 3 of the Act are not misused to deny any right or benefit to person with disabilities covered under this Act. Then, your lordship, kindly see section 20, my lord, employment, non-discrimination. And discrimination includes the reasonable accommodation also. Non-discrimination. No government establishment shall discriminate against any person with disability in any matter relating to employment, provided that the appropriate government may, having regard to the type of work carried on in any establishment, notification and subject to such condition, if any, exempt any establishment from the provision of this section. Every government establishment shall provide reasonable accommodation and appropriate barrier-free and conducive environment to employee with disability. Then section 21, my lord, equal opportunity policy, my lord. Every establishment shall notify equal opportunity policy detailing measures proposed to be taken by it in pursuance of the provisions of this chapter in manner as may be prescribed by the central government. The maintenance of every establishment shall maintain records of the person with disability in relation to matter of employment facilities provided other necessary including income manner. Then your lordship kindly see rule 8 and 9. Rule 8 and 9, my lord. There is also employment, my lord. Manner of publication of equal opportunity policy, my lord. Every establishment shall publish equal opportunity policy for person with disabilities. Establishment shall display the equal opportunity policy preparation. 3, my lord. Equal opportunity policy of a private establishment having 20 or more employees and government establishment shall inter contain the following, namely, facility and amenity to be provided to the person with disabilities to enable them to effectively discharge their duties in establishment, list of posts identified suitable for person with disabilities in the establishment, the manner of selection of person with disabilities for various post recruitment and pre-promotion training preference. There is also, my lord, the identification of post for PWD, not only for the PWD benchmark disability, my lord. And in the employment, my lord, the 4% benchmark has been given to the appropriate government. He has to appoint, my lord, 4%. Section 34 says, my lord, every appropriate government shall appoint not less than 4% of benchmark disability, my lord. That reservation for the PWD, my lord, under Article 16(1), horizontal reservation, my lord. Overall horizontal reservation.
No, these arguments you will not be permitted to raise now.
Yes.
Because you had participated, why should we
Yes.
allow
Yes.
you to raise all these arguments now? You participated. Had you been selected, you would not have raised these arguments. You are now raising these arguments on the ground that no, instead of 40%, 30%. Your case that you have made out in the pleadings is very simple. 40% you had been given earlier. Now, under reassessment, it has come to 30%. According to you, this is not permissible.
No.
Then?
When, my lord, Article 14 is violated, my lord.
Where
And,
is
my
the
lord, Article 21,
violation?
my lord,
Where is the violation?
my statutory
You
rights.
knew you could have challenged this. You could have challenged the advertisement on the ground that this is violative of the provisions of the Act. You did not. You
Yes, my lord, but
participated.
my statutory right, my lord.
What statutory right? You had waived it by participating it.
Yeah.
Assuming there is one. We are not saying there is one. Assuming there is one, you participated. You can't be allowed to blow hot and cold. You will participate. If you are selected, you will not challenge. If you are not selected, you will come before the court and raise issues about your constitutional rights. This is not permissible.
My lord, therefore, my lord, if my lord kindly see the judgment of the Honorable Appeals Court in Ravindra Kumar Dhariwal, my lord. In employment, my lord.
There is a definition of benchmark disability under the Act. Now the advertisement has given the benchmark disability at 40%. You participated.
My lord, the reason.
Your only ground is that whether the reassessment can be made by the state. If permissible, then you're out. If not permissible,
And even, my
maybe
lord, in my lord, my lord, the employment, my lord.
no, we had given you enough time. You've not been able to make out a case in that line.
Lordship, kindly sit.
Your
Please.
case is very simple. You should have stuck to that. You're trying to expand the scope of your matter. Why? Why should we even consider your violation of constitutional rights when You willingly participated.
My statutory rights, my lord.
You participated. Why did you not raise these
Even
issues?
participate, my lord. Even
No, no.
even I
You- we are asking you the question tomorrow. Supposing you are given appointment, will you still raise these issues?
No.
No.
Yes.
This is not a public interest litigation.
But when, my lord? But when, my lord, my fundamental rights been violated?
What
Whether
fundamental rights have
doctrine
been
of
violated?
stable,
Nothing, nothing, nothing.
the doctrine of stable.
You
applied,
show
my
us the medical
Yes,
requirement. When can you do it?
Lordship, Tuesday, Lord.
Tuesday, all right.
I can get the report.
Get the report we want to see.
Because-
If possible, you get the reports which were,
Communicated.
no. Come to page number 52.
Yes, Lordship.
Sorry, not 52. Where is the earlier one?
The order dated.
36.
Yes,
Come to page 36.
yes, Lordship.
36 is a disability certificate given by the Office of Joint Director.
Yes.
You get the medical reports from that office.
Yes.
You also get the medical reports of page 52.
Yes, sir. Then in that case, Lordship, it will have to come from Lordship Hojai, Lordship. Can it be on Thursday, next Thursday?
Thursday, all right. Heard learned counsel, Mr. Swanto for the writ petitioner, Mr. Swami, Mr. Somindu, Mr. Chaudhary, Mr. Neogi. And yes, you are appearing, MS Bora. And
Jay Gogol,
Jay Gopal
social justice.
for social justice. Yes. Have you noted what the apex court said yesterday? Only names of those counsels appearing and arguing in court will be recorded. So if you are recording your name, you better argue your cases. Matter has been heard at some length, and counsel for the respondents will for the what health department.
Yes, Lordship.
Health department will produce the relevant records, medical records. Will produce the relevant record on the basis of which the certificate, disability certificate, dated 10/1/2022, and the communication dated 8th February 2024 has been issued to the petition. So, let these documents be produced for perusal of the court if the need so arises.
And my lord,
On 27.
I have given the my lord list of the judgment.
Counsel for
Lordship,
petitioner has
Lordship.
furnished the list of it.
Lordship, Lordship, part third.
We don't know. We are fixing it on 27.
Pardon,
Part third matter.
I'm sorry, Lordship, I was in lag in court number 9, Lordship. Lordship, this matter is, Lordship, for non-payment of remuneration of the Bangladeshi worker and helper. Lordship, first of all, Lordship, I'd like to say that, Lordship, as per guideline, Lordship, Bangladeshi worker and helper must be local people, Lordship. Accordingly, they were engaged in the year 2007, Lordship. And at Lordship, Revenue Village and Moja Horinagar Part 3, Lordship, within bracket to Kergam. And thereafter, Lordship, in the year 2012, Lordship, the authority verbally instructed to work at Revenue Village to Kergam, Lordship, which is about 27 kilometers away from my original place of work, Lordship. And the direction was, Lordship, to take the additional charge, Lordship. And accordingly, we have taken charge, Lordship, and made a resolution, Lordship. And thereafter, Lordship, this was, Lordship, for in the year 2012, Lordship. And up to the Lordship, it was mentioned that Revenue Village to Kergam is a complete separate Revenue Village crossing over two big rivers, Lordship. And thereafter, Lordship, by the two orders, Lordship, the Respondent Authority allow me to continue my original place of work, Lordship, on 4/11/2019 and 26/2020, Lordship, as per Circle Officer's report, Lordship. And accordingly, Lordship, we started continuing our work, Lordship, in our area, Lordship. And thereafter, Lordship, Respondent Authority stopped my remuneration, Lordship, from since November 2020, Lordship. And thereafter, we filed a writ petition, Lordship, before the Honorable Court, Lordship. And Honorable Court directed us to make a representation before the authority, Lordship. And accordingly, Lordship, at page 16, Lordship, kindly see the order, Lordship, of the Honorable Court, Lordship. Here, Lordship, operative part is at page 17, Lordship. Petitioners are given the liberty to submit their representation to the concerned authorities with regard to their grievances within 1 week from today. The representation should be submitted to the responsible court, who shall thereafter take a decision on the same within a period of 1 month from the date of receipt of a certified copy of the order and the petitioner's representation. And at page 18, Lordship, have a look at page 18, Lordship. I have submitted my representation, Lordship, with details, Lordship, written statement, Lordship. And no order was passed, Lordship, on receipt of this order, this representation, Lordship. And thereafter, we filed this writ petition, Lordship. And in this writ petition, Lordship, during pendency of the writ petition, Lordship, we have also filed an additional affidavit, Lordship. Additional affidavit at page, Lordship, 51, Lordship. In this main writ petition, Lordship, our engagement letter is at page 19 and 20, Lordship.
No reply.
No reply, Lordship, by the authority, Lordship. Our engagement at page 18, Lordship.
Why no reply? Did you file any contempt petition?
No, Lordship.
Once you have an order, you should pursue it.
Lordship. Thereafter, Lordship, our engagement letter is at page 19 and 20, Lordship. Where, Lordship?
Have you seen the earlier order?
Yes, Lordship.
Page number 16.
Yes, Lordship.
Page number 16 is very clear that at this stage, you are given liberty to submit representation, which you did.
Yes, sir.
Thereafter, no order has been passed.
Yes, sir.
Ordinarily, you should have filed a contempt for violating this directive. Now, what is the instruction here?
Lordship, last order, Lordship, at 5/4, Lordship, 5/4/2024, Lordship. While, Lordship, the Honorable Court directed to take instruction, Lordship, where our center is within the proximity of the village, Lordship, Harinagar Part 3, and nearby the school, Lordship. School name is, Lordship, 1617 number, Dakin Harinagar LP School. This was the instruction, Lord. At 5/4, on 5/4/2024, Lordship, order taken. And now, Lordship, presently, Lordship, the day before yesterday, Lordship, they have started the termination copy, Lord. Terminating us.
Terminated, you challenge it.
Yes.
What remains now?
Lordship, but Lordship, where, Lordship, in this order, Lordship, they have terminated us, Lordship, on, Lordship, the year 2024, Lordship, and let's see at page 57, Lordship. On 10th June 2024, Lordship. And our remuneration was stopped, Lordship, since November 2020, Lordship. We will challenge, Lordship, but within that period, Lordship, we are entitled, Lordship, because, Lordship,
You raise these issues. We'll permit you to withdraw and file
Yes.
a fresh one.
Lordship, I will file, Lordship, certainly, Lordship, but within that period, Lordship, we are in service, Lordship.
No, Lordship, no work, no pay.
No.
We are working, Lordship, as per additional affidavit, Lordship. I have filed at page 51, Lordship. Kindly see, Lordship.
So we can't give you orders in piecemeal. Firstly, there was a direction to file a representation. You filed it. No order passed. You did not pursue the matter. You come up before this court asking for direction. Now you say that you are terminated.
Yes, Lordship. Presently, Lordship, during pendency of
So
this,
you challenge the termination if you want to.
we will challenge, Lordship.
But this writ petition, what do you want to do about it?
Within that period, Lordship, they pay our remuneration, Lordship.
There is already a direction to file representation that has been filed.
The petitioner filed, but lordship, we did not file contempt lordship against our higher authority lordship,
Right,
considering all aspect lordship.
counsel for the party. The writ petition is filed by the petitioner who claims to be employed as a Wanganwadi worker and helper in the year 2007 at C number 58 Harinagar, Part 3, Tukar Gram, Wanganwadi Center under the Katigura ICTS project in the district of Kachar, Assam. It is the submission of the petitioner that since the date of her engagement, she has been rendering her services. She had, it is submitted that since the date of engagement, petitioner, one petitioner,
Two petitioners, sir.
two
One is
petitioners
worker,
were
one is
rendering
helper.
services by setting up an Anganwadi center over a plot of land bearing tag number 499, Patta number 107, situated at Revenue Village, Moja, Harinagar, Part 3. So, sometime in the month of September 2012, the CDPO Katigura ICTS project verbally instructed the petitioners to work at the revenue village of Pukargram as additional work up to 2013. So, accordingly, the petitioners also covered the revenue village Pukargram uh, as a part of their additional work. So, the grievance to the petitioners are that as per the as per two orders passed by the ICTS officer, respondent number 5, the petitioners were directed to work at their original place of work on the basis of inquiry reports. The petitioners submit that their remuneration has been stopped with effect from which date?
November 2020, lordship.
November 2020. Being aggrieved, they had approached this court earlier by filing the PPC number 1791 of 2020. The state writ petition came to be disposed of with a direction by order dated 3/3/2020, permitting the petitioner to submit representation to the concerned authority with regard to the expenses within 1 week from the date of the order. The state representation, if submitted, was directed to be disposed of within a period of 1 month from the date of receipt of a certified copy of this order and petitioner's representative. So, pursuant thereto, petitioners filed their representation dated 21/3/2020. Where is the submission of the petition that notwithstanding the directions contained in the dated so and so, passed in the so and so, and the representation dated so and so filed by the petitioner. No orders were passed by the respondent. Being aggrieved, the present writ petition is filed. Para. During the submission made before this court, counsel for the petitioner has submitted that the petitioners have been terminated from service with effect from
From the last order, lordship, at page 34, lordship. 20th June 2020, Lordship. On receipt of this order, Lordship, we have stopped our work in that additional charge, Lordship. From this center.
No, you said you have been terminated now. You have been informed.
Yes, Lordship. Presently, Lordship.
Where is that?
Lordship. Additional affidavit they have filed, Lordship. Page 57. Lordship. Termination order is at page 57.
Yes.
57.
Yes, Lordship.
That was on June 2020.
Annexure 3.
Of which affidavit?
Lordship,
They have filed,
affidavit filed by the respondent, Lordship, on 18/3/2025.
Pagination figure.
18/3/25.
Lordship. Recent.
It's submitted. Page number, annexure.
Annexure 3,
three.
Lordship, page 57.
It is submitted by order dated 10th of June 2024. The petitioner have been terminated from the voluntary service of Anganwadi worker, Anganwadi helper, respectively, from 258 number Harinagar, Part Roman 3, paragraph Anganwadi center. The order was issued by the CTPO, Katigora ICTS project, Pachar. This is not under challenge.
No, sir. Just received, Lordship. It is not communicated to the petitioner, sir.
This order is not under challenge. Present proceeding. But under such circumstance, in terms of the earlier direction issued by this court and pursuant to which the representation has been filed, the respondent will serve any copy of the order that may have been passed, the representation filed. Or if not passed, then a speaking order be issued and a copy thereof be served on the respondent, on the petition. So, since the termination order is not under challenge, petitioner is at liberty to seal the same if so advised in the meantime. With the above observation, petition stands order is post. Yes.
Looking for some accommodation in both years. So, Inati that we having some difficulty for the
Mhm.
complete. So, admission very near the
Non-payment of gratuity.
Yes.
So section 4 of the gratuity act says, my lord, even if the
So
employee
there is
resigns,
a prayer made. Is there any
Yes.
objection?
No.
No
the
objection.
next week Tuesday, my lord, is
No,
possible.
no, that's not Tuesday. Mhm. Mr.
HR,
H.
HR.
HR counsel appearing for the respondent submits that the arguing counsel, Mr. D. Nath, is not available in court. Seek the cooperation of the day. Mr. S. Biswas, counsel for the petitioner, does not object. Prayer made. He, however, submits the matter be repeated again on 29th of April
29th of
2019.
my lord.
Yes.
Meetings completed, my lord. The other side, or was there, my lord? I don't know. This is in respect of, my lord, seal, following the seal cover procedure, ma'am. That has not been followed, so we filed it. Para 11 of my writ petition, the entire history of my case has been mentioned, my lord. Para 11, my lord, page 10. That it is stated the petitioner being eligible has not been considered for promotion. It is further submitted that pendency of the departmental proceeding criminal case is not a bar for the consideration of departmental promotion or at best seal cover procedure ought to have been adopted. It is pertinent to mention here that immediately after promotion dated 20th/6/21, the petitioner approached the higher ups and tried to find out as to whether seal cover procedure has been followed or not at the time of selection and promotion. To the utter surprise, the petitioner was informed that no seal cover procedure was being followed. Now, Lordship, they filed their affidavit. They want to say that, my lord, because of DPC, they have not been promoted. But, my lord,
Hmm.
Lordship may see page, my lord, 82 of the affidavit on opposition, my lord. Page 82, my lord. The ground has been set forth here, my lord.
Hmm.
I'm reading, my lord, second para, my lord, para 4, second para, my lord. Regarding the petitioner's promotion, Vijay Kumar Singh, who is currently serving as Assistant Executive Engineer Civil in the Public Works Department, has been considered for promotion to the rank of Executive Engineer Civil since the Departmental Promotion Committee meeting held on 18/8/2020. Since then, 6 DPCs have been conducted, but the petitioner has not been found eligible for promotion. The petitioner failed to submit the annual property return statement. Will mark this word, my lord. Annual property return statement, which is a mandatory requirement of a gazette officer every year, and his annual confidential reports were not available in PWRD. In all 6 DPC held to date, the petitioner was consistently deemed ineligible for promotion to the next higher rank. An officer of the government who do not submit the IPR and MPR is in time shall be denied vigilance clearance case and shall not be.
He's what? He's a deputed employee. He's on deputation.
No, not deputation, my lord. He is working as an assistant executive engineer there, my lord.
Then why his ACRs are not available?
That is what we also did not understand. But if your lordship see the promotion page, my lord, all the DPCs, my lord, lordship may see first, my lord, page, my lord. Page 97, my lord, may we see first, my lord. Oh. Yes. Page, my lord, first, my lord, page 86, my lord. 86, my lord. Then 86, page 93, my lord, is first DPC, my lord. Page 93. Well, lordship see, his name is there, Vijay Kumar Singh. Instead of ACR, it is just not available, all this ACS, my lord. Then, my
You're
lord,
reading from which page?
93, my lord. But there's the first DPC held on 18/8.
What is there as page 86?
86 is a DPC, my lord, of minutes, my lord, of 18/8/2020, my lord. Lordship will see the top portion, my lord. Minutes of the selection board meeting for selection of officers for promotion to the rank of Executive Engineer Civil and PWD from Assistant Executive Engineer Civil to be held on 18/8/2020. This is the first DPC, and page 93, his name is there, my lord. 93, lordship may see, of the second name, my lord, Vijay Kumar Singh. In every, my lord, year to year, ACRs were there from 2014-15 to 2018-19. It's written not available, my lord. Then next DPC held on 19/6/2021. That is page 96, my lord. Lordship may see page 98. Lordship, yeah, Lordship see the note, my lord, at page 98. Note: Amarendu Sharma, Assistant Executive Engineer Civil, has not been recommended for promotion as he did not submit the annual property return for the year ending 2020. So there is a specific against somebody, but me, that is nothing has been mentioned that I have not submitted my property details, my lord.
Where is your name?
No, it's not there, but I'm not. If they would have rejected my claim on that basis, my lord, then like the other person, it is written that his property statement is not there, so he could not be. But mine is not there, madam. And then, my lord, Lordship is the next column C, my lord. The selection board decided to keep the recommendation of Prasanna Burma against RR number so and so under seal cover. So there is one person that's kept in seal cover. Mine is not kept, my lord. Then next promotion, my lord, 30/12/2021, my lord. Page 107 be seen, my lord. Page 109. My name is reflected, my lord, at serial number 14. Not available. The ACR is with them, my lord, but then again, my lord, DPC on 3/8/2022, page number 115, my lord.
Oh, but where is your name?
My name is there, but against the ACR, it is written that not
Where
available.
is your name? Let us.
Oh, name, serial number 14, my lord, page 109. Serial number 14, Vijay Kumar Singh, DP in bracket, disciplinary posting, that means, my lord. Then lordship is
Serial number
14, my lord.
14.
14.
14 is Dinat Ali Ahmed.
No, page 109, my lord.
109.
That is 30/12/2021, DPC, my lord.
What is DP?
Disciplinary proceeding, my lord.
Yes.
I'll show more, my lord, from the record that it is written that not available, my lord. Then again, page 115, my lord, it is DPC held on 3/8/2022, my lord. Now here, my lord, lordship will see the last, my lord, departmental proceedings, my lord, page 115, my lord. That is minutes of selection board meeting held on selection of officers for promotion to the rank of Executive Engineer Civil PWD from the Assistant Executive Engineer Civil PW held on 3/8/2002. Here, my lord, last column, my lord, serial number 5, departmental proceeding. As per the record available, there is no departmental proceeding adverse report pending against 96 numbers of Assistant Executive Engineer Civil, zone of consideration for 24 number of posts, except Shri Vijay Kumar Singh. So mine, just because, my lord, that DPC pending, my lord, so it's not been considered. Then again, my lord, page 122, my lord, that DPC held on 2010/2023, my lord. I'm at serial number 1, my lord. Page 82 may be seen, my lord. Page, sorry, my lord, page 118 may be seen, my lord. I'm here, serial number 1, my lord, because then page 122, my lord, the 5th DPC, my lord. Column number 4, lordship may be seen, departmental proceedings, except Vijay Kumar Singh. So he is not been considered because DPC is pending, my lord. Then again, last DPC, my lord, on 16/2/2024, page 136. The page 137, my lord, departmental proceeding, that is last call, serial number, my lord, 4, except Vijay Singh, my lord. And there is one more, is
How many departmental proceedings are there?
6 DPC were held, my lord.
So what happened to all these DPC?
DPC held, the officers are promoted, but I have not been considered for, because my seal cover procedure has not been followed, my lord.
What is the conclusion? of the
Conclusion,
DPC?
my lord, Lordship may see the officers who were selected for promotion, my lord.
Forget about officers. In your case, what has happened to the DPC?
Not considered, my lord. Not considered.
No, what was the result of the DPCs? Where you found, where you absolved of or charged with
No,
the,
nothing, my lord, because only thing is my DP is pending, my lord.
how many
Because
years?
2000, actually the fact is that since 2018, the allegation when comes Shokus notice is issued, thereafter the DPC has 6 DPC held. I have not been considered. My case is that considered me, but because the DPC is pending, that's why it has not been considered, my lord. Since 2018, my lord. Now, my lord, Lordship may see, I'll just show one reply, my lord. My reply, my lord, I've given a reply to that, to this, my lord.
But if the DPs are pending, you should pray for a direction to complete the DPs
But
instead of asking for promotion.
no,
If the
the
DPs are
prayer
pending,
is there, my lord. The prayer is indeed I paid for that, my lord.
Yes.
And Lordship, interestingly, one thing can be seen, my lord. Now they are asking, but page 158, my lord, my reply. Vijay Kumar Singh, Lordship may see serial number 4.
so your prayer number 2 will have to be dealt with first.
Yes.
And my lord, on top of that, my lord, if
Huh?
on top of that, my lord, if the petitioner was not considered in the 6 DPCs that has been held from 18 to 2022 or 23, which are part of the affidavit of opposition, the petitioner will have to challenge the, my lord, DPC minor, my lord, the decision, my lord. That is not there, my lord, because we have brought in record in the affidavit. So there is a fresh cause of action. Without, my lord, holding that, my lord, DPC to be bad in law, how can he claim, my lord?
So DPCs were DPC did not consider because it's a department proceeding
Was
being
pending.
carried. What
Yes.
is the status of
My lord, that only in para 6 we have stated that it is pending, my lord, for the final inquiry report. Para 6. The affidavit filed by respondent number 1.
As per law, my lord, the department procedure has to be completed within 6 months, my lord, and they have to follow the seat cover procedure, my lord. Now they are saying that my property statement not furnished, my lord.
No,
But
your DPs are pending. You can't be considered for
Yes.
promotion.
no,
The
but
only thing is that you want them to be put in the seal cover. But
seal cover.
what is the use of six departmental proceedings?
Yes.
What is the use of putting them in seal cover?
My
When
lord,
the
But
DPs,
that
DPs
time,
have
my
not been
lord,
complete-
that time my ACR was there because Lordship will from this page number 148.
First, you deal with the DPs.
DP.
What is the status of the DP?
DP,
Have you been
I
served?
think, no proceeding has been
No
carried.
proceeding means show cause notice.
Showcause only showcause. Not. I've given my reply, my lord.
you've given the reply.
Reply.
Inquiry officer appointed, not appointed, what?
Inquiry officer appointed, my lord, but nothing is proceeded thereafter, my lord.
I will let it be on then only on that point, my lord, 26 or 28, my lord, I will have the status of the DP. So then lordship can dispose it of within a time frame, my lord, considering the present status of the DP.
First, your
26
DPs
or
will have to
28.
be completed.
Yes, DP has to be done, my lord. But if it is since 2018, my lord, now it is 2025, my lord.
So you don't have instructions. Let him get the
My
instructions.
lord, only on that point.
Let him get the instructions.
Right.
Where? What is the status of the DP?
Right.
Mr. J. Roy, Senior Counsel, assisted by Mr. Deputy. Here's Petitioner, Mr. P. Roy, Standing Counsel, PWD, submits. Is permitted to obtain instructions with regard to the several departmental proceedings initiated against the petition, which the petitioner claim has not been proceeded with and are presently pending. So, counsel for the petitioner does not have information.
Lordship, page 34 is the last communication to me, my lord, page 34. Preliminary hearing of the above mentioned department proceedings fixed on 12 February 2024. That this is the last communication made to us.
January 2024, as per the communication dated 9th of January 2024, whereby the petitioner was informed that the departmental proceeding is fixed on 12 February 2024 at 12. So, he, however, supposed that on the assigned date, no proceedings were initiated. Thereafter, no communication has been received about the further progress of the department. So, Mr. Gugoi will obtain
On 4th, my lord.
Huh?
On 4th of April.
and
Right.
submit that site report. So, let the matter be listed again on 4th of April.
Right.
Obliged.
Yes, Commissioner.
The prolonged delay, Lord. Covered case of Devapatra Tiwari, Lord. The DLC, Lord, not recommended on 9/8/19, Lord. It was rejected by DLC, Lord. And he approached before the court on 24, Lord. So after 5 years, gap of 5 years, Lord. It's purely covered case of Devapatra Tiwari, Lord. And then now it's 10 years already left.
Have you seen the last order?
Lord, that instruction, Lord. Recipients.
Lordship has placed one instruction whereby the date of application which the department received from the petitioner was 2019.
It has not been considered.
Hello?
His instructions reveal that it has not been considered.
But since in earlier occasions, they placed, they made the statement before this honorable court, saying that the DLC has considered the case of the petitioner, then it was forwarded to the SS. Now, my lord, this misleading facts are coming out, my lord, how it has happened. If
You bring it on record. Let him get it on record.
yes,
And throw it to him.
that I may be provided because this 19 this DLC letter which was rejected, madam,
that has been placed in the
Let them-
repetition.
Let them bring it on record.
Yes, I may be allowed to get this.
No, let it be brought on record.
No. Yeah.
So that if you want, you can rebut it.
Yeah.
In deference to the earlier order, dated 7/3/2025, counsel to the response placed before the court fresh instructions received from the department, which revealed that the DLC, that the matter was placed before the DLC, but the DLC did not consider the matter in view of a delay of 4 years in filing the application for compassionate appointment, seeking compassionate appointment by the Remuneration. Let the respondents bring the relevant material on record by way of filing an affidavit. It's after 2 weeks.
Only I would like to say, my lord, this 19, whatever they have shown this DLC of 2019, it was rejected by them, and that part has been brought into the record in the repetition. Here, my lord, immediately after the death of the father of the petitioner, he was got accident, major accident. Then his mother submitted the application. That has not been considered. They have not taken into consideration. And this honorable court, after considering all this aspect, my lord, and even Devadatta Tiwari case, this honorable court says that no, because in time this application was submitted, you did not consider it. It is your fault. That was the case. And now they are saying that after 4 years, they have this DLC was pulled, and all these things that they brought the allegation. That was ignored by this honorable court in earlier occasion. In the first motion stage itself, it was considered, and honorable court said no, this cannot be the consideration since instruction was called for. Then honorable court passed the order that he is a disabled person now, 50% disabled person because of the accident. Immediately after the death of the father, he got the accident, major accident. And these documents have been already enclosed here. And meaning thereby, this honorable court also come to the conclusion that this Devadatta Tiwari case will not be applicable here, because in time the application was submitted and it was not considered by the authority. And now they are saying that in 2000.
Let them bring it on record. Whatever materials they want to place it,
yeah.
Let their stand be clarified that it was not considered by the DLC.
Yeah.
Let it be on record.
Yes.
But the Devadatta stated that lordship, either applicant side or respondent side, delay lordship. This is clearly stated in 7.5.
We'll examine you. Bring it on record first.
Yes.
Bring it on record.
Yes.
Please again after 2 weeks.
Obliged, lordship.
I do reckon. I do. Yes.
Well, only one additional affidavit that I filed. I just want to apply this honorable court on that particular affidavit. That's already well submitted.
Where is your additional affidavit? You filed it?
Yes, my lord, it starts from page 231, running business.
Yes.
233, para 3, subpara A.
Yes.
Here it says, my lord, regarding the introduction of the GST from 1/7/2007, and the rate was 12%. So this will not be much relevant. Now, 3,
Yes.
Says, my lord, that out of the above sanction amount of so and so, my lord, here, my lord, B, my lord, the sanction amount for the work of the present case, which consists of one road so and so, is rupees so and so. The lordship will see the sanction letter, lordship will find that page, it is relevant, my lord, page 241. The sanction letter is of the Central Government Ministry of Rural Development. In the sanction letter itself, lordship will see the column, my lord, page 241. Below the column, my lord, the above cost is inclusive of goods and services. So they are the authority who has sanctioned the amount, and they say, my lord, it is inclusive of the goods and services. And this was sanctioned on, my lord, 8th of May 2018.
Where is it mentioned here?
My lord, 8th of May 2018, my lord, at the top right hand corner here. And my lord, below the chart, says, my lord, the above cost is inclusive of goods and services. So, my lord, present, my lord, work, which was sanctioned by the central government, my lord, they themselves have stated that, my lord, it will be inclusive of the GST. Now, my lord, turning to page 234 again, my lord, para C. So out of that sanction amount, an amount of 4 lakh was deducted for, my lord, preparation of the DPR, that is detailed project report, cost of the DPR. And so far as the maintenance part was concerned relating to this particular work, that was, my lord, that amount was related, that amount was to be borne by the state government. That is stated in para C.
Yes.
Now, my lord, one relevant clause, my lord, we have been relying upon, my lord, I repeat again, my lord, that is a clause number 13.3 of the contract agreement, which says, my lord, that all duties, taxes, royalties, and other levies payable by the contractor under the contract or for any other cause shall be included in the rates, prices, and total bid price submitted by the bidder. This particular clause was there already in the, my lord, contract, as well as in the NI clause.
Which page?
Page, my lord, 248.
240?
248. The relevant part of that particular, my lord, contract is, my lord, enclosed.
240A.
248, my lord, 248. 13.3.
Yes.
All duties, taxes, royalties, and other levies payable by the contractor under the contract or for any other causes shall be included in the rate, prices, and the total bid price submitted by the bidder. So this was a condition, my lord, in the contract itself as well as in the tender. Before submission of the bid, the petitioner was aware.
Yes.
Now, my lord, again, my lord, turning to page 235 of our affidavit. Para E says, my lord, since, my lord, these documents, my lord, from the document it is discernible that, my lord, the GST is inclusive. So far as, my lord, the present contract is concerned, my lord, so whatever amount is quoted by the petitioner, we'll have to assume that, my lord, he has quoted the rate inclusive of the GST, because it being a tender condition. And this particular tender condition has not been put to challenge, that, my lord, it is in violation of the GST provision. Now, lordship will see, my lord, one relevant para is, my lord, in the next page, he says, my lord, till June 2020.
Next.
Next page, my lord, 236.
Yes.
Till June 2020, my lord, all bids, my lord, or tender that were floated by the PWD under the PMGSY, my lord, Yojana, all were, my lord, inclusive of GST.
This was invited when?
It was in 2019. The agreement was of the work of the
Yes.
you will have a look at the annex. It was only after my lord 24/6/2020 the standard bid document was my lord amended, and my lord it was laid down that my lord the rate or the bid quoted by that bidder will have to be exclusive of the GST. That lord you will find that page my lord 258, 24th of June 2020. This is a my lord communication of NRRDA. All the my lord additional chief secretary, principal secretary, secretary under the PMGFY industry. Here lordship will see the para number 2. SBD, there is a standard bid document amended for quoting of rates without GST. Section 2, clause 13.3 now has been amended from 24th June to 2020. What you will see in the bracket section 2 slash clause 13.3. So it will be now from my lord June 2020, it will be without GST in the bid document. And in page 259, my lord, one my lord relevant page we have annexed of the subsequent bids that we have my lord plotted or tender that we have plotted. There, my lord, 13.3, what you will find, my lord, it says that my lord GST component shall not be added in the rate. So it was modified only in June 2020. Prior to that, it was inclusive of GST.
Why did you, what is there in 258?
258, my lord, 258, my lord, this is the amendment made to the standard bid document by the my lord competent authority. That is my lord NRRDA. In clause 2, para 2, lord, you will see. SBD is the standard bid document amended for quoting of rates without GST.
Then?
So, my lord, from my lord, June 2020, so the standard bid document clause 13.3 that I have pointed out, my lord, where it says it will be inclusive of GST. It has been amended to without GST. The price that will have to be quoted by the tender, it will have to be without the GST. So we have laid down, my lord, that particular clause or amended that particular clause, and it has been implemented from June 2020. A sample copy of that clause also will find in the next page. What you compare it with the page, my lord, 248 and 259, what you will find, my lord, that there is a modification. 248 is the earlier, my lord, bid where the petitioner participated. 259 is the modified standard bid document, clause 13.36. While quoting rate, the GST component shall not be added in the rate. Now it has been clarified, my lord, it has been modified in June 2020. Since the tender was of 2019, the earlier clause was there. It should be inclusive of this. So by these documents, we want to justify before the honorable court that, my lord, that particular NIT itself was quoted with the condition that the bidders will have to quote their rate inclusive of the GST. And that's why, my lord, the deduction was made while releasing the bid. That too, my lord, 1% is central GST, 1% or 2%.
So what you're saying is,
Right.
in this 258,
Got it.
this has come in June 2020.
Yes.
So prior to that, it was inclusive.
Inclusive, my lord, for that, my lord, I have placed the, my lord, sanction letter also, my lord, at page that I have just now pointed out. 241. It says that, my lord, the amount that has been sanctioned by the central government itself, the Ministry of Rural Development, that the above cost is inclusive of GST. Inclusive of GST. So accordingly, my lord, we have, my lord, plotted the tender. And in subsequent tenders, my lord, 259, just we are placing, my lord, that it has been modified. Now it is, my lord, without GST. All PMD my lord tender. And since it is a central funded, my lord, scheme, so, my lord, we have to follow their guidelines, as well as the standard bid document furnished by them. In addition to the affidavit that we have filed, to clarify. So the sanction letter, my lord, and these documents are not part of the first affidavit that we have filed.
Yes.
Lordship, to the annexure A41 that has been shown, that is the, if Lordship takes that for a moment, the 241 will say
241.
241, the additional affidavit that is.
Yes.
He has shown in the tabular form, the last part he has shown the above cost is inclusive of GST. That is why he has shown. Now on the top, what is written there? On the basis of the recommendations of the committee, the ministry hereby accords clearance for the proposal as per details indicated below. Submit Lordship here, the government had given a proposal. The central government has given a proposal. This was the amount which was inclusive of GST. Then when the contract agreement ought to have been drawn, which says as per the earlier thing, they would ought to have mentioned that the GST would have been, the amount would be excluding of GST, because 9(4) says that it has to be excluded. It's the recipient which has to be there. Now, by virtue of they on their own had not, if the exclusion of GST was not correct, then why in 2020 they changed it? They had changed it because that exclusion had to be there. Because they had, here the bills are prepared. Suppose 100 rupees is a bill, 18 rupees have to be added to that part. So when we had given the document, when we had quoted the price, inclusion of GST was not there, because GST in any case, we are not liable to pay that GST. So there is no question of including that the GST in that part. This is my respectful submission, because 9(4) says that.
What is the provision of GST?
9(4) lot.
GST account.
But if I prepared the written argument, I quoted the 9(4).
Yes, 9(4).
But in my written argument, I have just quoted the 9(4).
Yes.
The government may, on the recommendation of the council, by notification specify a class of registered person who shall, in respect of supply of specified categories of goods or services, or both, receive from an unregistered supplier, pay the tax on the reverse charge basis as the recipient of the supply of goods or services, or both, and all provisions of this act shall apply to such recipient as if he is the person liable for paying the tax in relation to such supply of goods or services. So that is the calculation. Now, that's why they had made it in 2020. Now, in our part, we had not included GST component there.
Are you relying on any authority?
Lordship, I have not got any such authority on this thing.
You have to.
I will, Lordship, I mean, in just, I have not got any authority, but I will just tell my senior as well in this effect.
Some authority in support of your case that your case is that 9(4) mandates are very clear that it is on reverse charge.
Yeah.
Therefore, there was no question of you quoting GST inclusive.
And that is vindicated by their documents when they changed their SPT. Why is the change? And they had, this instruction was given on 6/6/2018 itself, which I have already given in the, that they had already told us how it will be done. They had not done it. So that is the.
Now, what do you say regarding the approval or sanction or whatever is
That,
given here?
that I have, Lordship, that I read, Lordship, just now. The approval, the proposal that was given, it's a proposal. If the proposal was given that this amount that you are given this amount, now you But there has to be GST is included. This is the amount that we'll get for the construction of the road. Now someone will quote less or whatever it be. So that part will be the GST part. You have to then, when the quoting part will be there, it has to be clearly mandated that GST will be over and above the amount quoted by the intending contractor, whoever gets the bid.
No, no. See, if the mandate of the statute is on reverse charge,
Yeah.
then obviously the government does not have the latitude to change that
Yes.
procedure.
Here, when it says it is only a proposal, the above cost is inclusive of GST. What is it? In my respectful submission, it is saying that the proposal that this is the amount of money you are getting to build this road, which will
Which you want to submit that this is just a sanction to the total amount.
yes,
Which
this is my
includes-
submission.
Which includes GST.
GST.
But the share of GST is to be paid on reverse charge basis.
Reverse. That when we tender was put, this is the
All right.
Here, my lord, so far as our part is concerned, also will have to see section 51 of the GST.
Yes.
50. And it has been notified by the central government. I will say that also is part of our.
Yes.
It says deduction at source. The notwithstanding anything to the contrary contained in this act, the government may mandate the department for establishment of the central government or state government or local authority to deduct tax at the rate of 1%. Here we have deducted 1%. 1% from the payment made or credited to the supplier. Hereinafter in this section referred to as the deducting of taxable goods or services or both, where the total value of the supply under a contract exceeds 2,50,000 rupees. So, my lord, it's more than, my lord, 50,000 rupees. Then, in fact, my lord, we will see 9.4 again, my lord. So, 9.4. It says, my lord, the government may, on the recommendation of the council, by notification, specify a class of registered persons who sell in respect of supply of specified categories of goods or services, or both receive from any unregistered supplier. We will receive it, my lord. Unregistered supplier, in that case, it will be a reverse. And petitioner being a class 1A contractor, he is a GST registered contractor. His registration will have to be there. It says, my lord, very categorically, from an unregistered supplier, receive from an unregistered supplier. We are the, my lord, employer, my lord. We will receive from him. And lordship will see, my lord, the affidavit again, my lord. Here, my lord, it is of 10th of October 2018. There is a guideline of the, my lord, finance department regarding, my lord, deduction of TDS by the DDO against GST, under GST. So above, my lord, 2.5 lakh. Page 250, lordship will see, my lord. Page 249 is the notification. 10th of October 2018. Annex E. Page 50. Documents for TDS registration. For registration as tax deductor, the following information are required. We will be deducting the tax, so we will be registered, my lord. For the establishment, that office, so and so, so and so. 6 days, my lord, the DDO. DDO means, my lord, disbursing officer, my lord, dealing and disbursing officer. Or the authorized signatory is required to make an application online in GST REC 7 in the GST common portal on behalf of the tax deductor. Tax deductor will be the employer. The step-by-step user manual for applying for registration as tax deductor is available in the portal of the Commissionerate of State Taxes Assam. After the application is successfully submitted by the applicant, the same would be approved of by the respective jurisdictional officer. Once the application is approved, the DDO or the authorized signatory will receive the GST number in the given email ID along with the initial password. 8 will be relevant. Tax deductor is required to deduct TDS amount from the payment to be made to the supplier or deductee. Deductee is the supplier at the rate of 2%, 1% state GST, 1 central in case of intra-state supply, and 2% of IGST in case of interstate supply. Once the deduction is made by the tax deductor, the TDS amount is required to be deposited by the tax deductor in the government account within 10 days from the end of the month in which the deduction is made. Now, 10 is the procedure for deduction and deposit of TDS. So, my lord, we being the deductor and petitioner being the deductee, we are entitled to, my lord, to the needful, my lord. And who are the deductors is at page 249. It says, as per section 51 of the Act, the following entries are required to do TDS and thus are required to get them registered as tax deductors. Under section 24, Roman 6 of the Assam GST Act. A department or establishment of the central government or state government, local authority, government agency or persons or category of persons notified by the government. This is a notification of 2018. We were following this matter. From 2020, when the notification came, and we have followed accordingly. Madam.
Yes.
You can show some authority or
Yes, yes. Show some authorities if you want.
getting that.
Who? You are supposed to show some authorities.
Yeah.
Okay.
Any date?
You tell us when you want it.
Got
25th?
25th of March.
Yes.
Yes, yes.
Okay, Lord.
No, the 27th.
Lordship, 27th I'll be out. 25th or maybe after 1st or 2nd April.
Maybe one around 1st of April.
1st or
1st of April, all right. 1st of April. Heard counsels for the parties for further hearing on 1st of April. Hearing remain inconclusive, further hearing 1st of April. Yes.
deeply open.
29.
Yes.
Directed to place the relevant information before the court as to whether the screening committee has made necessary inquiry and after the screening in respect of the requisition as to whether with effect from the date of regularization, that is 2022, there is status of employment and any other, whether any records to that effect are available. Lordship, here, I have received instruction to the address before your Lordship, where it says, in the screening committee forms that were previously shared by government letter number 7, the Barak Valley Division has remarked that the appointment does not appear to conform to the criteria given in the guidelines issued by the government of Assam, number so and so, so procedures and selections and appointment doubtful. Vacancy position and selections are also not backed by the authentic official documents available with the district office. So that instruction is there, Lordship. And if your Lordship, there were individual verification notes. So I have received a soft copy of the instruction today, which contains 192 pages, Lordship. I have
Furnish it to the
shared,
court master.
and Lordship, one of the verification report, I have placed it before your Lordship. If your Lordship comes to the page number, please back to that page.
Yes.
If your Lordship sees this report, there is an individual report. At
Where? In this one?
page number, Lordship,
Yes.
second last. This is individual. We have individual report in this verification.
How many petitioners?
80 petitions. This Ali Ahmed Korbhuya is one of the petitions.
Yes.
Now, Lordship, if it comes date of birth, so and so, so and so, so and so, appointment at the bottom, appointment letter number so and so. Third column from third row from the bottom, appointment letter number. Initially, appointment by memo number so and so, and regulation as per cabinet decision, government order number so and so, dated so and so. Appointment letter number so and so, dated so and so, so and so. Appointment authority, in both the cases, it is DEO Kasar, DE
No,
Assam.
you are referring.
Page number, the first page of the report, Lord.
Huh?
Last
This
page,
document.
second last page,
Second last.
Lord. At the back side.
Yes.
The heading is Educational Department Teachers Appointment Verification System. So, third row from the
This
bottom.
entire document you have it in the soft copy.
Lord, soft copy I have.
Send it to the court master.
And Lordship, I have already emailed. Lord. And the next page, Lordship, if your Lordship sees appointment is genuine or not.
Hmm.
Records are not available at the office of the DEO and DI office. No record. Appointment basis regularized on adjustment. Selected properly or not. Records are not available at the office of the DEO or DI. Now, Lordship, remarks. Appointment does not appear to conform to the criteria given in the guidelines issued by the government of Assam, letter number so and so, dated so and so. Procedure of selection and appointment doubtful. Vacancy, position, and sanctions are also not backed by the authentic official documents available with the district officer. So these are the reports, and individual reports are there, Lord. And so far as their working status is concerned, on the last page, Lordship may kindly peruse at the back. Working particulars. From 30/11/1994 to 21/8/2005, remarked so and so MB school as assistant teacher. 23/8/5 to 10/10/14, so and so school as assistant teacher. Duties for these particular. So from 2014 onward, no, he is not teaching. Duty certificate duly signed by the head teacher of concerned school. So from 2010/10/2014, this particular petition is not working. So accordingly, I have placed the individual verification status, Lordship, of all the. And as I have already filed our affidavit clarifies everything, Lordship. They were subject to the screening committee in terms of the advertisement made by the government. In terms of the cabinet decision, they voluntarily participated in the screening committee. Some of the petitioners, they appeared before for some of the petitioners, their records were not available with the screening committee. So that part I have already applied to Lordship. Our affidavit at page number 65, filed by the response number 1, which says, Lordship, in terms of the cabinet decision, Lordship, page number 63, paragraph number 6, how the screening committee was constituted. That the answer independent, that the answering independent humbly begs to state that in compliance with the order dated so and so, passed by this honorable court in WPC number so and so, the education department placed the matter of regularization of irregularly teachers before the cabinet in its meeting held on so and so, so and so. Thereafter, the education department proposed to constitute a screening committee to examine the validity of the appointment of these teachers. Accordingly, wide OM dated so and so, a screening committee was constituted to examine the cases of irregularly appointed teachers so as to take a decision for their regularization and entitlement of salaries or otherwise, with a view to examine the selection procedures, the nature of appointment, status of post, working status of salaries, academic qualification, etc. The Director of Elementary Education, Assam, invited application from the illegally appointed teachers during 1991 to 2001 throughout the state by an advertisement dated so and so, so and so, and so and so. Two advertisements were there, and they voluntarily participated. That in response to the state advertisement for screening
screening applications were received from illegally and irregularly appointed teachers throughout the state, where these petitioners, some of them, apart from some of them, most of them participated. After conducting preliminary examination at the director level, the Elementary Education Department, by notification dated 22 constituted 5 screening committee headed by the divisional commissioners concerned and principal secretaries of 6 scheduled area and BTC to examine these applications, and the report of the preliminary committee. The said 5 screening committee were for area wise. 8. Thereafter, the divisional screening committee verified all the applications and submitted their reports.
What to that?
Lordship. And Lordship, here, important is paragraph number 12. Who participated and whose records were not available. Paragraph 12, Lordship. Page number 66. Married Lordship.
Yes.
That the answering, paragraph number 12, Lordship. That the answering department humbly explicit that the name of the petitioners in the present need petition, except these petitions 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Few petitioners were found in the screening committee report under Kasar district, but they have not fulfilled the criteria of receiving the salaries up to 2007 and onwards and having JBT, DLA, etc. as laid down in the cabinet memorandum. Hence, they could not be accommodated as teacher. And further, in respect of these petitioners, 10, 12, 13, 14, 71 to 75, no records were found in the screening committee list. As such, their cases could not be considered for accommodation. So, Lordship, they appeared before the screening committee, they did not fulfill the criteria, and while considering their cases, individual status of the individual petitioners were verified, which I have said before now.
Yes.
That screening committee, which they are referring, that was constituted in terms of the order dated 2/3/2010, passed in the double petition number 1048 of 2004. I am already submitted several times. He also knows that the petition pertains to a separate set of teacher. That pertains to drop teacher,
No,
not in the
no,
present pre-petition, because that present
no, no, all
petition.
right. Let us say that this is not a committee. Let us accept your argument that this is not the committee required to set up to verify your
Yes.
document. But there is a committee which verified it.
Earlier, before
This-
2005, regularization.
This committee, even this committee verified and found that you do not
Because-
fulfill the criteria.
That is why, this committee, that drop teacher, drop teacher category separate.
Whether it is drop teacher or what you say, stipendary teacher or whatever teacher, honorarium teacher. Fact is, there is some committee which had gone into the records to find out, and their findings are that the materials
yes,
are not
ma'am.
available.
I am very much appreciating that matter. But in this case, what happened in this present petitioners, their services were regularized in the year 2005, after being recommendation by the Asmonon committee. That committee, that teachers, that set of teachers, they are different. All of our Assam, other teachers are getting their salary. Only at the instruction of finance department, they are the district teacher of the in the Assam district, their salaries were disturbed.
Yes, there was a.
Now what I'm submitting, madam. Now
You did not
earlier
file.
also-
You did not file a reply to the affidavit.
No.
Yes, madam. I have categorically stated that particular 1048 does not include by teacher present description, because they are separate set of
In
teacher.
response to the affidavit which was filed.
Yes, madam. I have submitted. I have stated that is not covered with the rate.
There is no any statement controverting the
I'm
stand of the department.
You have given omnibus statement that they are working regularly to the utmost satisfaction. Is that all these records are not available? These particulars which have been placed before the court, you are not disputing that specifically. So we are closing the hearing.
No, my lord, there's something, there is something to come out, my lord. And we give some time.
We have given you enough time from
Yes,
2
my
to
lord.
the
Everybody
12.
got the enough time, my lord, but conclusion part, my lord, that well, referring the petition number 1048, my lord, that created the problem, my lord. Because, my lord,
We are asking you a specific query that there was an inquiry done by this committee. Let us accept that according to you, this is not the committee
yes, yes,
constituted.
my lord. That
But
that,
they have procured certain records, verified, and they've returned a finding that you do not fulfill or your records are not available.
my lord, yes, my
Now,
lord.
in response to that, you have filed a reply
lord,
affidavit.
kindly appreciate one thing, my lord. The committee, my lord, that was that screening committee, my lord, that was formed in terms of the WBC in the WBC 1048, my lord, 2000, which I am referring that was pertains to my lord drop decision. In this case, my lord, the screening committee has laid down three paragraphs, three category, my lord. That three category, my lord, that have already stated in their affidavit, my lord, that someone who is, they have reached their salary up to 2007 or not, or who are obtained the BT degree or not, my lord. And some other categories also there, my lord. Now, this category, my lord, the present petitioner cannot never fulfill, my lord, because they have never received their salary.
They have never received salary.
Yes, from their date of
Yes.
regulation,
So
they are
they come
extracting
under-
their services, my lord, and now they are not paying anything, my lord. And their service, their service,
No, like
they are not denying, my lord.
hard reserve. You are closing it.
My lord, one last chance, my lord. I will appraise your lordship, my lord. What is happening? And moreover, my lord, now they are submitted only one thing, my lord. Out of 80 petitioners, my lord, they have only one record.
No, I have already placed.
No, but
the
they
soft
should have
copy.
also served to us, my lord.
Give him a copy.
I
We have not served any copy, my lord. Just having a copy to court, my lord. I
That is,
became helpless, my lord.
no, you have been given the particular,
My lord, everybody, they are also getting.
uh, you have filed a reply affidavit where you did not disclose these disputes. You did
Well,
not say that.
I
That
said,
these
my lord,
records cannot be available.
That is separate sets of teacher, my lord. That is not applicable in the present description.
Salary not received is one thing, but there are materials to show that you were not even found to be working. You have
My
not
lord,
responded to
my
that.
lord, yes, my lord. There may be discontinued from service, my lord, but
Right?
I am what is the prayer in the
So
present
who will
petition?
verify in the absence of the record? How
The
will the
present-
authorities find it?
Doctor, even on the finance
My lord,
department also on verification
education
found
department,
their
my lord.
academic were
All
fake.
are the education department, my lord.
That is why
Kindly
the
say that
After
CID.
the 2012 matter,
My lord, I am also, my lord, I am also getting.
this entire delay which has been caused has resulted in this. Can't help it.
Yes.
What specific directions can be given now? Nothing. There are no record.
My lord, reports, my lord. That is the thing, my lord. Education department is the only part of
You
CASA
go
district.
and
They have
file
to.
complaints before the whatever authority you think of. You are asking for
Ultimately, they have to
salary.
take the decision, my lord.
Huh?
Because I have served, there is no disputed, my lord. There is no dispute
You have
by the department
served.
also, my lord.
You have served, but there are no records to support your contention.
My lord,
There are no records.
they have, my lord, they have, earlier, my lord, filed a petition, sorry, my lord,
Oh, we are closing it. We have heard enough. Enough.
My lord,
Several
you have
hearings.
lost, and I am very much appreciating your loss that you have lost your beard so much with this.
Then
My lord,
why
now,
do you
my
want me to bear for more?
I
Let me
want to
close
give
it.
one last chance, my lord. Kindly let him
You
forward the
furnish
document.
that
I will
soft copy
give
to
you the
him.
soft copy also, because it contains 192 pages.
119 you can print out also, man. What a
I will
190
I will
pages.
sort in the
I
soft
can
copy.
keep 190.
You save it in your whatever laptop or
Okay.
iPad or whatever you have and go through it.
Just leave it. They even cannot print out single document here, man.
27. So one last chance. Whatever you can find out, otherwise we are closing it.
My lord, can it be on heart
No.
of
Huh?
heart of April, my lord? Not in the Ramzan.
Oh. 3rd of April. Okay.
Heart of, right.
3rd of April.
Well,
appointment of counsel for the parties. Counsel for the petitioner, matters hence referred to be listed on Tribunal. Mr. P.N. Sharma, learned State Counsel, has placed before the court the records pertaining to the writ petitioner, on the basis of which the inquiries have been made. Stop. Yes, since the records are voluminous in nature, he has submitted them in soft copies to the court master, who will connect it to the case record after taking necessary printouts. The State Counsel is permitted to furnish copies thereof in soft copy format to the writ petition. Yes.
Obliged.
The matter is very, my lord, now limited, my lord, parameter. I was appointed as Angalwadi worker, and there was some allegation made against me. I also lost an affair, they also lost an affair. Subsequently, my lord, on the basis of some report which was prepared behind my back, no department proceeding was initiated, nothing of the sort. They issued the, my lord, impugn order in terminating my service. Holding that, the allegation made against me is unproved. Now the, my lord, law is well settled. In one of our decisions, my lord, our High Court says, in case of Anganwadi workers, my lord, some disciplinary appeal rule is, my lord, made applicable. Therefore, they are supposed to, my lord, hold inquiry.
Where is your appointment order?
My lord, that's fine. My lord, it is a very old petition, my lord. Everything is obscure, my lord, because it's transfer matter. It has come to my chamber on transfer. At page, my lord, 18. To go. Judgment. At page 18. It appears that there was some selection, and in terms of the selection, I was appointed. It was 33. As it appears from the impugn order that, my lord, no any inquiry was held. I was not given any opportunity. Simply, my lord, they referred that a report was prepared by Deputy Commissioner, and Director issued a direction to the project officer to terminate this. Allegation is, my lord, they also lost an affair, I also lost an affair.
What happened to the criminal cases?
On my criminal case, nothing, my lord, still pending. So far, my instruction goes. Initially, they submitted FR. Then I filed Naraji petition, then cognizance was taken, and my lord, case was registered.
Where is the judgment you
My
want to
lord,
refer?
yes. In a similar situation, there was some allegation and referred that para 3.
Where is the that other judgment?
Other judgment matter I could not procure. Madam.
How-
Or if necessary, I can obtain the judgment matter. WPC number 6925 of 2010. That was the law. 69. 05. 2010. Now, on consideration of that fact, the interim order was passed. It was. Okay, it- 9.
Are you a government servant?
No, no.
Mr. Purvester,
They are, my lord, getting remuneration from public exchequer.
are you a
In
government
other case also, my lord. My
Are
lord,
you a government servant? But this is a voluntary service, isn't
Yes,
it?
Lord.
exactly, it is a voluntary service.
Well,
Even then, court has observed that once you are going to take some disciplinary action,
No, court
And-
has observed because the query was made
yes,
and it was answered by the parties that yes, we are governed by it. So
then, my lord, I will have to examine this question
you have
because there are other aspects of the matter. Because in one writ petition, I have moved a writ petition before this court seeking promotion, and court was pleased to, my lord, issue rule and wants to examine this question. In that case, also a question arose whether you are a government employee. And
prima facie, it appears you are not a government servant.
exactly, my lordship is absolutely right, because it is some sort of, my lord, offer made to me to render the voluntary service. But whatever remuneration I am getting, this is a part of public exchequer. And Patna High Court, my lord, of course, I am not having this judgment today. Patna High Court, Allahabad High Court, they say, yes, there is a scope of promotion. And and their government has framed the rule
We have
in
a
other
rule.
state.
We have a rule regarding a promotion of Anganwadi worker, Anganwadi
Helper to worker.
because we have a rule. But it is
Now the
completely a
question-
voluntary.
Yes.
Well,
Now-
do you get a remuneration?
No, Lord.
Lottery has absolutely right, my lord. This question is obviously, my lord, relevant question, whether we are a government employee or not. I will examine this question. I will address the report.
How is it that you have come for hearing without examining this
My lord,
since
I thought, my lord,
2014?
I thought, my lord, my case is covered by this particular judgment.
Of course, it is covered, but then we'd also like to find out whether you are
Right, my lord,
government
right.
Before this, Lordship,
And they did not file any affidavit. They also did not raise this
because
question.
Lordship, this writ petition is not as per the proper procedure. Because Lordship, the impugn order is not annexed here. Lordship.
Yes, we have an act.
No. This is whatever they relied upon this is the page 33. Page 33 is the show cause notice, Lordship. It is categorically stated in the page 34, Lordship. Page 34, last
Oh,
paragraph.
53,
Yes, page 34.
page 53.
Yes, 53.
53, impugn order is there.
Is the impugn order?
No, 53 is not.
Termination order.
No. 53 is the application filed by.
No.
Yes.
Page 53, a termination order.
Yes.
Annexure I.
Yes.
That was issued by the government authority.
Lordship. First, they have to prove because Lordship after show cause, Lordship. After giving the due opportunity, Lordship, this inquiry was
not-
conducted. And
It's a different issue, but there are orders of this
yes,
court.
therefore,
That cannot be said to be a proper opportunity. I reply this, I'm submitting my reply. No consideration.
You
nothing
share
has been done.
the orders with Mr. Goswami. Let him also examine this matter.
Lord.
Because there is an order, there are two orders of the court where it says that this rule is applicable.
Yes.
If we have to follow this order, then we are to allow the writ petition. So the question is whether this rule can be made applicable to services
Yes,
beyond the
yes.
government.
That was not getting.
Matter be listed after 2 weeks. After 2 weeks.
Whether Loshi is, my lord, asking me to address the court on this point.
Yes.
My lord.
After 2 weeks.
And my lord, so far as my lord, my contention is concerned, two courts in two decision appliedment rules. There is no any appeal on their part. They didn't even file any, my lord, affidavit.
It is
raising
open
this
for
question.
us to refer the matter to a larger bench by
Yes.
framing a question.
Yes.
But then we would like to know
My lord.
your argument on
Yes. My lord, after two, my lord,
prima facie. It doesn't appear that you are a government servant.
right, my lord, Roshi is right.
And
Oh.
unless the department has taken conscious decision to
lord.
apply the rules,
My lord, may I request your lordship, my lord, that the matter come up after 6 and 7 months, appeal. I will out of station, my lord. 7,
we'll have it after the vacations, 24th,
my lord,
24th of April.
my lord. And my lord, interim order may be out to continue.
It will continue. Whatever is there is.
My lord. Obliged.
Yes, Mr. Nath.
My lord. My lord, petitioner in this case was appointed as a sweeper, general attendant in the State Bank of India. Pursuant to selection process, my lord. The selection was for temporary appointment of a sweeper, my lord. From 2004 till 2004 till today, my lord, he's working that post. What happened in 2010? While he was being treated as a regular employee, he was sent to a particular branch and he was being paid, my lord, daily basis. In 2015, we came before the Honorable Court. Ultimately, on 16, my last on 16/6/23, this Honorable Court disposed of this matter by allowing the writ petition. What happened at the time of my lord hearing, last occasion? In the select list, there are two persons. One is Shubhendu Nath, and I am in select number 2. At the time of hearing, on that day, I placed the document before the Honorable Court. My lord, kindly see. The serial number 1, although they were selected for temporary appointment, but selected number 1 was regularized. This is pay scale. I submit the document before the court with a copy to other side. But there was no pleading because just previous day I got that document. So the Honorable Court took this paper, passed the judgment. Against that judgment, my lord, they won. They went to the retail court. They said that there's no pleading. Honorable Chief Justice asked me, is it so? I said, yes, my lord, there's no pleading. I placed it like that. Then the Honorable Court directed me to do one thing. I'm reminding the matter back. You filed that document, but you have an affidavit, and the matter will be heard by the single judge. So it has come with your lordships to them. Now, lordship, may please come to page number 14, my lord. There's an he was working as a canteen boy on 28/9/22. This is to certify that Paplu Nath Kachar has been working as canteen boy at the State Bank of India.
Page number
14 Annexure 1, my lord. This is to certify that Paplu Nath has been working since September 2099 to September 02. His sincere towards his duty is remarkable personality. During 3 years of tenure, SBI Noshim branch, he has never been least deviated from his own responsibility. Energetic sons joint manager. Next is important. On 9/1/24, my lord, kindly see this letter. Empanelment for temporary appointment of general attendant sweeper interview. It has been decided to hold an interview in connection with preparation of a panel list for temporary appointment of general attendant at 21-24 region office. As your name has been sponsored by the District Employment Exchange for the purpose, you are requested to appear before the interview board on the scheduled date time. You are also requested to bring following documents, my lord. Next is the select list, my lord. Page number 16, Annexure 3.
your matter
Yes.
was last was listed in 2018.
It was no, my lord. Judgment. The judgment, lordship, can you see the judgment? It was disposed of
Judgment was disposed of in 23.
16/6/23. Yes.
Prior to that, in 2018.
Yes.
What happened in between?
No, it was not listed because it was not listed because of the COVID. After a long time, it was listed. Now, page 16, my lord, kindly come to page 16. This is a select list. Staff subordinate, preparation of panel for temporary appointment of general attendant sweeper for the district of Kachar. With reference to the above, we have to advise that an interview for preparation of a panel list for a temporary appointment of a general attendant at the branches of Kachar district held on 22/1/2004. The list of successful candidates in order of merit along with their permanent address are furnished below. Shubhendu Kumar Nath, seal number 1. Number 2 is Paplu Nath. This is the petitioner today, my lord. Next, paragraph 2. Please, therefore, arrange to make necessary arrangement for replacing the existing temporary general attendant, if any, presently working at your branch from the above panel list, and also note to utilize their services on purely temporary basis whenever necessity arises in future, such as leave, death, retirement, etc. As the new panel will be enforced with immediate effect, the old panel shall cancel. Please also ensure that no candidate gets protection of such and such. My lord, then your lordship may please come to page number 20, my lord. That copy is the type, original copy, I gave a type copy. Page 20 is the appointment letter, my lord. Annexure 4. The Paplu Nath. As per regional office panel list of temporary appointment, you are hereby temporarily appointed as general attendant sweeper at this branch with such and such. Now please come to page number 23, my lord. This is a corrected related document. This is page number 23, the dated 2/12/205. State Manager, State Bank of India, by branch manager, Mrs. Sri Premlal Balmiki deceased. We have to advise that Sri Premlal Balmiki, sweeper, expired on 2/12/23. Since then, the sweeping work of the branch premises was done by engaging a daily labor till 14/6/04. Because no permanent sweeper is posted, the work is being done by Sri Paplu Nath, who have reportedly been engaged from the panel list of sweepers maintained at regional office temporary capacity. In this connection, we would like to advise that salaries of allowances of Nath is being paid through the establishment register with a break of 1 day, such and such. Incidentally, Sri Nath is found to be sincere in his duties, obedient too. We shall therefore request regional office to make arrangement for his absorption permanently as sweeper of the branch. Now, please come to page number 24, my lord. Page number, lordship is got it, page 24, my lord. Dated 8/2/06.
Yes.
This is by the assistant manager to the my lord, subordinate recruitment sweeper such and such. In this context, we have been advised by our regional or general office Guwahati that they have already taken up the matter with the appropriate authority for sanction of the post. Then it is 25, my lord. 11509. This is by the branch manager to the assistant manager, Guwahati. Request for creation of PF number of Prabhunath in terms of the tentative instruction dated 11th instant such and such. Guwahati advising us to create PF number Paplunath temporary appendant with the department to enable him to pay his salary from the month of April 09 through the such and such. We shall therefore be glad if you kindly arrange PF such and such. There are three. We have already taken up with the ST manager for payment of salary for temporary, my lord. This is now page number 26.
Yeah.
Page number 20, Annexure 7. This is allotment of P index number, the Paplunath. This number has been given, my lord. With reference to letter date such and such, we have allotted a PF number. In this connection, please arrange to send the enclosed form such and such, my lord. This is what. Now, please come to page number 27. That's dated 7509. That's annexure, my lord. This is to the assistant manager by branch manager. Salary of general attendant. With reference to the above, we beg to advise that Sri Paplu Nath has been appointed on purely temporary basis as general attendant sweeper full-time on 15604. On the demise of a permanent sweeper, Premlal Balmiki, who died on 2/12/03, from the pen and list of appointment of general attendant sweeper for the district of Kachar, which was prepared at the regional office, Silchar. And the same has been circulated to the branch on such. We are since utilizing the services of purely temporary basis full-time sweeper. His salary allowances are being paid by department to charge account number. This is what March salary such and such, my lord. The salary is 6,277, left side, my lord. Then please come to page number 28.
Yeah.
Page number 28, dated 5/6/2009, my lord. This is to the chief manager by the branch manager. Appointment of temporary general attendant, Sri Paplunath, Silchar Bazar branch. With reference to the
Who
Silchar
is for
Bazar,
the bank?
State Bank.
Who is for the bank?
I'm for the bank.
Yes. He was selected. He was appointed pursuant to selection.
I was appointed pursuant to a selection when there was a vacancy which arose by the death of a grade 4 staff in the bank. Thereafter, the local employment exchange had recommended certain names pursuant to which the interview was taken.
Hmm.
And when the interview was taken, there was a list of selected candidates whose services were to be utilized at various branches of the bank. And there was a caveat in the appointment that the appointment are purely on a temporary basis. Your Lordship will kindly come before, I would not like to interrupt my senior here, but there is one small detail at page 70.
Page?
Page 70.
17.
170, Your Lordship.
Yes.
Please, therefore, arrange to make necessary arrangements for replacing existing temporary general attendant, if any, presently working at your branch from the above penal list, and also note to utilize their services on a purely temporary basis whenever necessity arises in future, such as leave, death, retirement, etc. As the new panel will be in force with immediate effect, the old panel stands cancelled. Please also ensure that no candidate gets protection for employment in banks services. That was a list of employees which was selected by the bank for utilization on an ad hoc basis if need be, or on a basis of continuous service as need be, as the need would arise.
Now, this Sivendu Kumar
Yes, yes. There's a detail here. The parity which has been drawn by this honorable court on the earlier occasion when disposing of the writ petition. Your Lordship will kindly take up the last affidavit that we have filed as a reply to my senior friend's affidavit in opposition. Your Lordship,
Yes.
the affidavit starts from page 60.
Yes.
Yes. Your Lordship will kindly come to page 63. I've appended the relevant annexure also. Page 63, Your Lordship. There was a parity which was sought to be indicated
before this honorable court. Paragraph 12 is where you have repeated the stand that Shibendu Kumar Nath is not on an equal footing with the petitioner. Thereafter, your lordship will kindly come to page 64. 64, next page. Paragraph 13. Your lordship has got that. Your lordship has, yes.
Para 12.
Para 13. 12 is at page 63. Thereafter, your lordship will come to the next page at paragraph 13. That be that as it may, Sri Shibendu Kumar Nath was subsequently regularized, and the case of Sri Shibendu Kumar Nath cannot be equated with that of the writ petitioner, inasmuch as the two are not similarly situated. Unlike the writ petitioner, Sri Shibendu Nath had been working as a canteen boy from September 1990, and thereafter he worked as a cleaner with the bank in the year 1997. It is pertinent to mention that before 15/6/2004, the petitioner had never worked with the bank, although he is a casual worker with the local implementation committee of the branch. It is submitted, then this is a submission. Then 13A, the next paragraph, that a settlement dated 30th of July 1996 between State Bank of India and the All India State Bank of India Staff Federation was arrived, where it was clearly stated that while temporary employees in subordinate cadre out of a panel so prepared were to be given a chance for being considered for permanent appointment in the bank against vacancies arising up to December 1994, daily wage casual employees out of a panel so prepared were to be considered against vacancies arising from January 1995 to December 1996, whereafter the said panels would lapse. Then the next line, your lordship, the deponent submits that even though the death of Sri Premlal Balmiki occurred after the cut-off date of January 1995, it is pertinent to mention that Sri Shibendu Kumar Nath was the only candidate in the list order dated 26/2/2004 who had been working in the bank prior to March 1997. That is the consideration which was taken to regularize Sri Shibendu Kumar Nath.
The petitioner never worked for the bank.
He worked for the
In
bank.
lecture 1, page 14, branch manager certificate.
No, that's a certificate just to say he worked for the bank, not as a bank employee.
What it says
Even after 2004, he was not a bank
specifically
employee.
says.
No. He's not a bank employee, therefore he is
He was
asking for
working in a
regularizing.
canteen. He was working in a subsidy canteen run
Same
by the State
Shibendu
Bank
Nath.
of India.
Same Shibendu Nath.
Yes. But Shibendu Nath had been working from 1990.
Page 14,
Whatever
kindly
it
see my
may
And
be.
his case is covered by the settlement, your lordship, which is at page
No.
79.
The difference you are trying to make out
Yes.
is that he used there's a statement that he never worked for the bank. Petitioner.
Your lordship, the statement is
Uh.
that he was working for the local implementation committee, which was run to run the subsidy bank of the State Bank of India canteen. He had come into the State Bank of India fold for the first time
What is
in
this?
2004.
What is this page number 14 certificate?
Specific.
Page number 14 here, your lordship, does nowhere indicates he had been working as a canteen boy. That is not in dispute.
Come to the last line of the first paragraph.
During his 3-year tenure at SBI Narsingpur branch, he has never left. His tenure was that he was working. He was an outsider. He was a third party who was engaged to carry out the services at the State Bank of India. There is no dispute the fact that he had been working in a premises which is owned by the bank. But he, for the first time, your lordship, the petitioner had come into the fold of the State Bank of India by way of the order at page 60, 2004. And Sri Shibendu Kumar Nath was also similarly situated with like the petitioner, but he had been working from a time prior in 1990.
Maybe.
And there's a reason, your lordship, the reason why the case of the petitioner was.
So this is a very artificial distinction.
In fact, your lordship, the settlement.
That distinction has to be on German ground.
Yes, the German ground, your lordship, starts at page 79.
Settlement, how will he know what settlement?
Yeah, it's
He's
there.
a canteen boy, he's working. You have regularized one fellow who was selected with
He
him.
regularized one fellow because he filled certain criteria which have been laid down in the
This
settlement.
criteria, are these criteria German? You are asking for regularized, you are expecting service of this person.
we are extracting service and we're really paying him.
You are
There
paying
is
him.
absolutely no
You're
dispute. The
paying him,
fact the
but-
petitioner has been working for us
but-
diligently, and there is no dispute. We are not.
What was the reason for regularization of Subhendu Nath?
Yes, because the vacancy arose. Your lordship will kindly come just for a moment at page 80. Page 80.
18.
80, your lordship, the last document.
Hmm.
This is a settlement between the State Bank of India and the State Bank of India workmen.
Hmm.
And page 80. Whereas in terms, the second paragraph, your lordship, whereas in terms of the aforesaid settlements, while eligible temporary employees in subordinate cadre out of a panel so prepared were to be given a chance of being considered for permanent appointment in the bank against vacancies arising up to December 1994, daily wage casual employees out of a panel so prepared were to be considered against vacancies arising from January 1995 to December 1996, whereafter the said panels would lapse. This was the understanding, and this was the understanding based on which, with utmost humility, I'm submitting. I have nothing against the petitioner services. In fact, services have been taken without being regularized. But these are the norms that were followed by the
What
bank.
norms? We are unable to understand you.
Vacancy, the Premlal, Your Lordship, Premlal Valmiki was a general attendant in the bank who had
You
expired.
show us the vacancy in which this Sibendu was regularized. When did the vacancy arise?
That vacancy arose, yes, Your Lordship, that vacancy arose after 1995, in 1997.
Then it goes contrary to your agreement itself.
Your Lordship will kindly see our statement.
You come to page number 80.
Yes.
It is your agreement.
Yes, the vacancy should have arisen, as Your Lordship had rightly pointed out, from January 1995 to December 1996. The petition, Mr. Premlal Valmiki expired in the year 1997, just 1 year thereafter. And since Sibendu Kumar Nath was working for since 1990, that leverage was given. But the petitioner joined the fold of the respondent bank in the year 1999.
See, you are finding grounds not to give the benefit to the petitioner. This is different from saying that he does not fulfill the criteria, or there is no that the parameters are not being fulfilled.
The petitioner,
You are flouting your own agreement and
us,
accommodating somebody. And in the case of somebody else, you are saying that no, these grounds are not applicable. How is this possible?
with utmost humility, Your Lordship,
You are an employer
I'll
in the
submit,
nature of a state.
with utmost humility, I'm submitting that we're not finding ways to discharge the petitioner, but we have found one way to accommodate one person. That is my
We
submission.
are not on that. That person is not before the court.
That
The
person
person is before the
I have
court.
got
is
no
one
grievance
who is
against
not
that
on.
person. No grievance at all.
There's no grievance.
That
The fact
person
is
who's
sought.
before the court
Yes.
is also asking for similar benefits. You confer it.
The same time benefits has been conferred based on something which was conferred to, apparently, somebody who's
You have to explain why this benefit was conferred to Siben. On what ground? When your agreement goes contrary.
The agreement, in fact, Your Lordship, the agreement had stated the cutoff date to be 31st December 1996. In 1997, just after the year started.
Whatever it may be.
Yes.
Whatever it
that
may be.
Premlal Valmiki deceased had died, and there was a
But
vacancy.
you accommodated by pending the rules.
Because we did not bend the rules.
You did.
We tried our best to accommodate. In fact, there's been no. Your Lordship had seen by the annexures that my learned senior friend had shown.
Yes. Is there any post available now?
He's working. Still today he's working.
No.
But,
Is there any?
Yes, that post has not been filled up. Still, in Valmiki post, still it is working.
He is working against Valmiki post.
Yes, that this is post, permanent post, sanction post.
And the Subendu?
Shubhendu is working in another post, not in Valmiki's post.
No. It is my submission on
No.
It is my submission on oath. If Your Lordship so desires, Your Lordship will fix the matter on Monday. I'll get instructions on this.
No.
As to what post.
From my document, it is very clear. It's specific from my document. I'll show, my lord. It is very clear. Page number 27. Writ petition. It's on record. Page 27. With reference to the above, we beg to advise that Paplu Nath has been appointed on pure temporary basis on a general attendance sweeper, full-time basis, on the demise of permanent sweeper Premlal Valmiki. This is
See.
what. It's clear from here.
It is there.
Yes, there are 27. Page 27. It's there.
It was
It was never disputed. Today, I don't know, first time I think, my lord.
it was Sipendu Nath who was accommodated against the Premlal.
This is your branch manager's communication.
In fact, the branch manager has urged on a lot of occasions where you have stated in the affidavit themselves that the earlier pay was 6,000, which was minimized. I'll get specific instructions on this, Your Lordship, then Your Lordship will dispose of the matter. I have nothing against the writ petitioner services, absolutely not. If this is the only criteria that Your Lordship will consider, on Monday I'll get the
No, it's not a question of only criteria for us to consider. We are asking you what criteria you want
that was
to
the
consider his case. You are giving grounds and reasons in a manner that the benefit should not be conferred to the
Your Lordship,
petitioner.
this sentence
Maybe you don't like his face. That's a
absolutely.
different issue.
There's nothing that we didn't the last councils to dispute on that, the services that the petitioner has been rendering.
No.
In fact, what has happened, Your Lordship, just sentences can
I don't mean the council.
But Your Lordship, what has happened is Your Lordship will kindly see the first order and this letter. It is my submission which might be corrected. It is not happily worded. The panel which was selected in 2004 was for engagement at various branches on a temporary basis as and when some needs might arise. And Premlal Valmiki, Your Lordship, was a permanent employee. If I was working against Premlal Valmiki, then I would have had a
See, Valmiki, my lord, Shubhendu's appointment letter, kindly see. Page 58. In my affidavit, I filed after the division which has passed that order, my lord. Filed on 8/11/23, page number 58. Shubhendu.
Yes.
Top 58 mark in that just below. Shubhendu Kumar Nath, Lordship is seen. Dated 3504. General attendant sweeper. With reference to the interview held on 22/1/04 for selection of general attendant, you have been found suitable for appointment as general attendant sweeper on 1/2 scale of pay in the bank. It has therefore been decided to appoint and post you in Kabugonj branch. Please therefore report to the branch manager to Bengal such and such. Next, kindly see, my lord. Next page. C is the total regular employee, my lord. First name, Shubhendu Nath. See the scale, it comes to 17,844 total. That is the document I placed on single judge. On that day, it was not pleaded. So the Honorable Division Bench told me, go and file this affidavit, along with the affidavit being to the record, my lord. And Honorable single judge will hear this. This is the only difference, last hearing and today's hearing. This document was not before the court by way of affidavit, today it is by way of affidavit. That's the only difference. And he's 20 years, my lord, now. He's working in the same post.
I am Paplu Nath, Your Lordship, because Bendu Nath has been given that post against the post of General Attendant Premlal Valmiki. That is not in dispute. That, in fact, 45 is my case. So I'll get instructions if there is any vacancy where he can be accommodated without an adversary litigation, because there's nothing against the petitioner here.
And my lord, another thing I want to point out, my lord. Another thing I want to point out. My learned friend relied on paragraph 13 of his affidavit, saying that Shubhendu has worked from 2003-4. My lord, this statement is not based on record. Please come to page 64 of his affidavit. Page 64. Lordship has seen, my lord. Now, please come to paragraph 13. Totally, they are relying on paragraph. This, my lord. 13. Now, please come to page 67. They are saying he's working from 1990. If that my lord, the document which annexed my lord settlement order, if it is applicable to not to me, then not to him also, because this is the statement they totally would make without record. Kindly see the affidavit part, page 67 below. Statements made in affidavit under paragraph 4, 5, such 13 are true to my knowledge, my lord. That's what. On the basis of knowledge, they're making the submissions and they're equating that I'm not entitled. It's 21 years now, my lord, I'm working the said post. It is because of this, my lord. Even I was selected. Honorable Single just directed, my lord. Only the difference, my lord. This document I did not annex last.
Which document?
That annexure in page number 58 and 59. These two documents. Single judgment.
Who's for the private respondent? There's someone.
No private, because I have not challenged the appointment. I got no grievance. I just want to show the example, my lord.
58 is been issued to Shibendunath.
Yes.
That is what I submitted to the Lord.
Yes.
Shibendunath was accommodated. There is no dispute to that.
We have understood that.
Yes.
What we have not understood is what is the criteria for not giving the same benefit to the petitioner. That's it.
There was one vacancy which arose after
He's,
the death of
uh,
Sridhar Balmiki.
No, your statement has to be supported by some official record.
It is on oath that I have gotten instructions. Your Lordship will fix the matter first thing on Monday to get instructions whether there is a post to be accommodated, and we'll surely try the same. Lord.
Tuesday.
Tuesday. Yes.
Matter be listed on Tuesday, enabling the counsel to the bank, Mr. M. Sharma, to apprise the court in respect of the claims made by the it's taken on Tuesday.
Obliged, my
25th.
obliged.
25th.
At 33, no? 33. My lord, 33 and 34 are tag matter, my lord. But what happens in this case, my lord, 33, my lord, petitioner number 2 recently died, my lord. They have to include their representative, my lord, legal representative. Petitioner number 2, Jawaharlal Chakraborty died, my lord. Recently, in March. 33.
You want to file an application?
I have to file a IIP. Jawaharlal Chakraborty died.
Mr. J. Sharma, counsel for the petitioner, submits that petitioner number 2, Jawaharlal Chakraborty, expired during the pendency of the petition. So, he therefore submits that steps is required to be undertaken for impleting or incorporating the legal heirs of late Jawaharlal Chakraborty in his place. So, he prays for
My lord.
3 weeks.
2 weeks, my lord.
2 weeks time. Take
Full
necessary
matters I
steps
was
in the matter. Mr. J. Goswami does not object to the prayer made. List again after 2 weeks.
May I pray for fixed date, my
You file the application.
Yes. My lord.
You have to get it completed.
34 tag matter, my lord.
You file an application.
Yes, my lord. Obliged.
33, 34 together.
My
Please, Your Lordship.
Yes.
Lordship, I am appealing on behalf of Senior Counsel Mr. D. Raj.
This is a review matter.
Yes.
You're appearing for the review petitioner.
I am appealing for the petitioner. For the petitioner.
For the state of Assam. Which matter, which item you are appearing?
35 and 36, sort of.
All right. Yes, what is your submission?
Your Lordship, due to some personal difficulty, Mr. Das had to leave court. Can the matter be adjourned for today?
The request made on behalf of Mr. D. Das, Senior Counsel, matters can refer to be listed after 1.
Your Lordship, can it be fixed after court?
1 week. After 1 week, if required, if you want a fixed date, make a mention.
Obliged.
May I please, Your Lordship? But I might take up some other. In this matter, Lordship, we have concluded our argument, Lordship, and Lordship was kept as part Lordship. But in that cause, this Lordship, it was not reflected.
Yes.
Then it is taken up on 1st of April, Lordship, subject to continue. Lordship, on the next week, Lordship, motion they will be discharged.
24th April.
24th of
April.
Lordship, my director registered to keep the so as part heard.
All right.
Whatever
Matter be listed as parted on 24th of April.
Lordship,
As it is submitted by the counsel for the respondent that the learned additional agent, Mr. D. Gutwami, will lead the argument on behalf of the respondent, but not available in court. Yes.
Lordship, can it be taken up of 22nd, Lord?
22nd, there are too many men. 24th, if you have a difficulty, you can have it on 29th. Yes. Next.
Then 24th, Lord.
Yes, 24th.
Item 40.
Also, in this case, senior counsel Kian Chaudhary sir, I am led by him, my lord. Can it be fixed on next 27? Matter relating to the suspension, my lord. In this, due to the pendency of this case, petitioner deprived from the getting pensionary benefit. So there is some urgency. 27, my lord. Next week.
All right, 27.
Master,
The request of counsel for the 27.
Master.